My lordship.
For admission, madam, tomorrow. Admission,
Pardon?
for admission, madam.
Admission. Admission will come.
Madam,
It will be posted.
the matter that is dismissed for non-prosecution, my lord. Non-prosecution, my lord. By virtue of the non-prosecution, the respondent moved the matter for the labor court, my lord, for the unfavorable labor practice.
So what is the urgency?
Urgency is, my lord, that is.
What is the urgency?
He filed an execution petition for the recovery of the amount, my lord.
For restoration.
Yes, sir.
Same about. Let it be restored. Twenty-first October.
One fact,
Lordship,
one contempt, my lord. One matter, contempt, my lord.
No, you choose either this or that.
First matter, my lord.
My lordship.
Commercial appeal, my lord.
You must have
Commercial
mentioned more
declared, my lord.
urgent matter first. Oh, then let it come in order in due course, yes.
My lord, this commercial suit declared against me, my lord. They
Pardon?
filed an appeal. Commercial suit got declared, my lords. And they filed execution, my lord. An appeal has been filed.
22nd.
My lordship on submission. Serial number 24 seeks adjournment.
Anybody? Yes. Yes,
Serial number 24, my lordship.
24.
24
Yes.
seeks adjournment. Short time may be accommodated. Even I have informed for appellate advocates also. We need to file an objection for an IA. So we received a
No. let it be.
copy on Friday, my
You
lordship.
remain present. At that time, we'll see whether to grant time. or not.
My
lord,
serial number
Remain
19.
present. Okay.
Your
If
lordship.
not, dismiss it for want to proceed. Yes, anybody? Yes.
My lord,
Yes,
Lordship, may I mention one matter?
Serial number 18, my lord. In the
Yes,
previous,
13%.
in the previous day, it was given for 29th of November. It's a reinstatement matter in service. The writ petition is ordered in my favor. It is ordered for reinstatement
It
and
is,
deno.
it is to come up on 29th November.
29th November, but
Then
I
you-
wanted it,
Then you file IA.
I have filed my lordship.
All right, post it on the 23rd of September.
Serial number 52, my lord.
23rd of October.
Serial number 52. my lord.
IA only. IA.
Serial number 18,
18.
18,
1
Wait for weeks time.
No.
Serial number 19. Next week, any date may be called.
Let it be called.
my
out, then
lord,
we'll see.
52, my lord.
my
Your
lords, we
lordship.
kindly have this matter anytime this week as the bank intends to take physical possession of my property.
Pardon?
My lords, there's urgency in this matter as the bank intends to take physical possession of the property. Appeal. Writ appeal. My lords, we kindly post a matter.
What is the urgency?
The bank intends to take physical possession of my property, my lord. They intend to dispossess me.
22nd.
Serial number 52, my lordship.
Yes.
That's serial number 19.
19. 19.
Short accommodation.
19.
Yes, madam.
I have an objection for this, your lordship. For the last 4 times they sought time and this has been happening since before the summer
No,
vacation.
that's
your
it.
lordship. I have
No,
the
senior
dates,
was
your
ready.
lordship.
Senior is not in town. He'll be coming today in the
We'll
evening.
consider when it is called out. You be remain present.
Serial number 52, my lord.
Yes, madam.
My lordship 52.
Serial number 22, your lordship. Senior is out of station, requesting for another date.
22. We'll consider once it is called out. You remain present.
52, my lordship. Serial number 52.
52.
Council on record gone USA, my lord. 2 weeks time may be granted.
6 2-week time.
Respondent number 1 to 13, my lord.
Why?
52, my lord.
Why?
Council on record gone to USA. Council on record gone to USA. my lord.
Council record gone to US. Not a very good ground. 23rd.
Next month, first week, my lordship. He returned back on first week.
Then let it be called out. We'll see what is it. Then remain present.
Serial number 87.
23rd, my lordship.
Now you remain present when it is called out. We'll see whether to grant time or not. Yes.
Serial number 87, my lords. It is a non-compliance of this objection. The objections are in the second set. serial number, sorry, page number 39 and 38 is missing.
80.
87, my lords.
So what?
Only objection is that in second set, page number 38 and 39 is missing.
So delay is there.
And a condition of delay we have sought an IF. Means 1 week time may be given, my lords. We'll comply with the office objection.
Given. For that you need not mention. 3 weeks time.
My lords, the date, a week date may be.
Date will be given by the court officer.
Much
By
older.
the court.
Your Lordship, may I mention one matter, Your Lordship?
Yes.
Your Lordship,
Yes.
may I mention one matter? My Lord, the read appeal is posted for 11th of November and I have filed one IA for preponement of the date, Your
IA
Lordship.
to be listed on 21st.
Read appeal number 1291 of 2024, Your
No, you
Lordship.
give memo, not like in this, not online. If
My
you
Lord,
have the
I am
memo
from
for
Odisha, my Lord.
Otherwise not on online.
My Lord, I am from
Submit a memo physically, yes.
Seal number 1, contempt matters, Mr. C.M. Nagabhushan.
Pay for the complaint, my lord. The lands of the complaint was acquired for Kempegoda layout. As per the notification, I am entitled for 40% of the developed land. I filed a 2 petition and the petition, this court was pleased to fix a time. Within 3 months, I must be allotted there. So far, they have not allotted in spite of my 2 representation, your lordship. Your lordship gets the order at page 15, your lordship. Para 5, last 2 lines, your lord.
Appeal is not filed.
Huh?
Appeal is filed.
Not filed. your lord.
Learned single judge while disposing of group of writ petitions issued following observations and directions in his order dated 7th November 2022. Which is the direction? Which is the direction?
At page 15, your lordship, para 5, last 3 lines. Submitted by petitioner in accordance with law within 3 months from the date.
Notice returnable on
Much obliged.
29th October.
Number 2,
Not 29th. 6th November.
seal number 2, Mr. Naveen Chandra N.
Compliance affidavit has been filed.
Compliance, keep back 2/3.
Seal number 3, Mr. Shirish Krishna.
Even here,
Number 3.
compliance affidavit has been.
2/3.
Number 4, K.R. Lingaraj.
Yes, sir. Complaint, my lord. Lord, petitioner, the complaint, my lord. Respondent is, my lord, violating the order of this court, my lord. Page number 8 is the order of this court, my lord.
It is not placed before. the
Relevant.
comment. Not placed before.
They
the
not yet placed, my lord.
Notice.
But similar matters, my lords, lordship have passed an order dropping the contempt proceeding. This is an ineligible application, my lords, where there is no land available in the village. And the act provides that the application shall be directly forwarded to the deputy commissioner, and deputy commissioner has passed an order.
Yes, we passed the order.
Passed an order, my lords.
You passed the order.
We have passed and I filed the affidavit, my lords.
No, they are not served the copies, my lord. Copies have been not served, my lord. Let them serve the copy, my lord. I have it on next week, my lord. I will look into the same and I made my submission.
Learned additional government advocate, Ms. Pramodini Kishan.
Thank you.
Has filed client's affidavit, has filed evident reply, a copy of which is served to learned advocate, Mr. So and so for the petitioner today itself. In that we put up at 2:30 on 28th of October.
Please, ma'am.
Number 5, Mr. Ravi Kumar BR.
Appearing for complaint in this case.
Weightage of what?
20% of it.
In what?
Permanent service, my lordship. They have not considered my
Notice returnable on 7th November.
much obliged. My lordship.
Number 6,
I'm appearing for the complainant, my lord. I'm appearing for the complainant, my lord. My lord, I'm audible, my lord.
Yes.
My lord, it is a case of the complainant has not been complied, my lord. Para 26 of page 45, my lord.
Page 45.
Page 45, my lord. The order, concerned order is in para 26 and 27, my lord.
Notice returnable on
Obliged.
11th November.
Obliged, my lord. Obliged.
number 7,
I'm appearing for the complainant, my lords.
Archana Murthy.
My lords, this honorable court, my lords, specifically directed to consider and pass appropriate orders, my lords, to conduct
Durasti
within
notice 12th November.
next also same, my lords.
Pardon?
Next matter also same.
Next same.
8,
Same.
We have filed the affidavit, my lords.
You filed.
We have filed the affidavit, my lords.
My lords, actually, my lords, what the affidavit they have filed, it's wrong, my lords. All the documents are available in the office. There is a grant order, my lords, RTC mutation, everything is standing in the name of the complainant, my lord.
R1 is the endorsement issued, my lords.
My lords, all the documents, it's in Kannada, my lords. I'll
The documents are available.
Documents are available, my lords. Recently, we have obtained from the
But
office.
the copies, copies are not relevant, my lords. They have to, there should be original documents that they have to produce. And those documents have to reflect in our records, my lords. Clearly, we have stated in page 10,
But
translated.
you are only saying that there are no documents regarding entries.
The
Lordship,
office only we have obtained, my lords. It's in Kannada. I'll translate and I'll file it, my lords.
Have you given some finding about this document?
but
Have you recorded something, any of the endorsement about this document?
please, my lords, your lordship may kindly see page 10, translated copy, my lords.
Page 10, yes.
Please. Saguli register, issue register is the mandatory document which is not available, my lords, for having issued the grant records.
then you file a petition, seek amendments. Contempt will not survive. Heard learned advocate Ms. Archana Murthy for the petitioner and learned additional government advocate Ms. Pranodini Kishan for the respondent. The contempt is alleged by the petitioner in respect of the following directions passed by learned single judge in his order dated 13th July 2022 while disposing of the writ petition. Page 13, paragraph 1 to 3. In response to the compliance affidavit in reply is filed by the Tehsildar Mandya Taluka, Tehsildar Tehsildar Taluka District Mandya, in which it is, along with which endorsement date, copy of endorsement dated 20th/8/2008/2024 is produced. It is stated in the affidavit while producing the endorsement that the relevant record was examined and documents regarding entries in RTC for the period from 1966-67 to 1985-86 were not available, and that the computerized RTC was available up to 2001. Paragraph following was stated in the affidavit. Paragraph page 9, bracket portion. As per this office file, starting therefrom, further action on 13/11/92. It was next stated that inspection was carried out. In respect of the entry in the Saguwali chit distribution register, but no such Saguwali chit was found. It was stated that no documents were available to show that the land in question was granted to the petitioner grantee. In absence of the substantial documents supporting the claim, the request for grant was negatived as per the endorsement. Paragraph. The operative part of the endorsement dated so and so reads as under, and page 11 regulated portion. What was sought to be contended by learned advocate for the petitioner is that the copies of the documents were available. However, they were not duly considered by the authority. On the other hand, learned additional government advocate will submit that the documents were only in the nature of copies, and neither they were original documents nor did they substantially support the case of the petitioner. Be as it may, paragraph. The court finds that once the endorsement is passed, the direction of learned single judge to comply with the are complied with, the contention sought to be raised in respect of endorsement by the petitioner travels in the realm of merits, which cannot be gone into in the contempt jurisdiction. Full stop. The contempt proceedings will not survive, they are accordingly disposed of. Paragraph. Liberty is our resort for the petitioner to challenge the endorsement in independent proceedings in accordance with law and on merits, the court, however, does not express any opinion on merits in respect of such recourse. For both same order. Same order,
18.
my lords.
identical
But
order.
please, my lords.
It's number 9. Mr. Keshav Murthy B.
My lord, I appear for the complaints, my lord. The complaints are made, my lord, this court by its order date on 4/7/2023. Page number 10, relevant page number 70.
Notice returnable on
Please, sir.
13th November.
Much.
Still number 10.
Appearing for the complaint in this matter.
John Paul.
My lord, complaint had initiated proceedings, my lord, through writ petition, challenging the validity of the gazette notification issued by accused number 2, my lord. This honorable court, after considering
Notice
my
returnable on 15th November.
obligation.
Still number 11. Mr. Venkatesh S. Arbati.
Complaint. The order of the land single judgment is at page 25. Not complaint, not even till today. In spite of not writ appeal being dismissed, in spite of SLP being. Notice written on 15th November.
Still number 12. Mr. A.V. Amarnathan.
There is a direction to consider my reference within 3 weeks. Again, earlier also, another reference on 28/8, still they are not considered. The writ petition disposed of with the direction at page number,
Page number.
the order at page number 13, para 6. In your proposal, refactions, I deem it just and appropriate to dispose of the petition directing the concerned respondent to
Notice
consider.
written on 16th November.
Okay.
Not 16th, 19th November.
Date.
Number 13. Mr. Kiran J.
May I please? By an order dated 3/9/2024, Learned Single Judge has directed for issuance of statutory notification contemplated under the UGC Act, which was directed to be done, my lords, as early as in December 23. Having failed, my lords, a mandamus is issued, whereby, my lords, the notification contemplates grant of a autonomous status. But after the receipt of the order of the
Yes. Notice.
lordship places, let's
This matter, first, it's for the first time it is coming up. We have prepared a writ appeal, it is listed today. It may be called along with the writ appeal. Serial number 80.
Lords may consider issuance of notice and lords may hear them also, because I'll be able to show.
Is to be heard with writ appeal number.
Please.
So and so. Give the number.
Please. You will see the serial number 83, 84.
Writ appeal 15/12 of.
Let's
57 of.
What is it?
let's may I just make a request, please?
Number 1512.
May I make one request, please? I'll be able to show that this writ appeal is on a misconception contrary to the express provisions. Now, there is a failure to comply with the directions which were ordered, my lords, to be complied in 2 weeks.
We'll consider once writ appeal.
Any delay, my lord, your lordships will be hearing it today, my lords, when it reaches.
No. Maybe taken up next week, any date, whatever is convenient.
Next week. Next week on 21st.
Please.
You remove the office objection.
Yes.
Lords, that objection, I believe, is having made the university represented by Vice Chancellor ought to have been by registrar. We have no objection, my lord, for correcting it.
Under the regulations, lords, the university is always represented by the registrar. But the petitioner has arrayed the vice chancellor representing. But
We
that
have
is-
no objection for corrections.
We'll consider 21st.
Please.
The PIL matter, number 14. The Nikhil Vital Patil, party in person.
Wait for the first question. Good morning, Your Lordships. My name is Nikhil Patil. I'm appearing as party in person.
So this writ petition is filed for,
You are a student.
yes, sir.
Which course you are undergoing?
Government Law College, Mumbai.
Law.
Government Law College, Mumbai.
So course of law you are.
Yes, sir.
You're in legal field.
Yes, sir.
You're
I'm
student of
finally,
law, student of law.
yes, sir.
So no other business to except to file PI.
No, sir. I approached the Archaeological Survey for conservation of temple. After that, from 2022, sir, I'm approaching these authorities. Let's kindly come to page A.
Have you approached the
synopsis.
authority? Have you approached the archaeological department?
Yes, sir.
Have you approached the archaeological
Yes, sir. Yes, sir.
department?
Harvard Circle. I approached them.
Where is that?
Kindly come to page annexure A, my lords. Page number 35. Page 35.
35.
Yes. This is the RTI, actually email sent to the Archaeological Survey in 2022. In 2023, sir, my lords, they surveyed the temple, but they didn't give any survey reports to me. They asked me to take this matter to the Deputy Commissioner of Belgavi to conserve this temple. So I made the Deputy Commissioner and the annexure C, my lords, page number 37. This is the application given to the Deputy Commissioner of Belgavi.
Is an archaeological monument?
Yes, ma'am. Yes, my lords. It is a temple, my lords, nearly 300-year-old temple.
Under archaeology department?
Yes.
It is under the control of department?
No, my lords.
So, what is the prayer?
So I wanted to register this temple with the Archaeological Survey.
Register the temple.
Yes, my lords. The RTA reply given by archaeology is provided, my lords.
So which are the provisions for registering? Which are the provisions for registering the monument as archaeological monument?
It should be, my lords.
Have you seen the act?
Yes, my lords.
Where is it? Which are the provisions? And what are the considerations?
According to the definition of
what are the criteria and considerations for declaring this monument as archaeological?
It should be ancient monument. And according to the act, my lords,
let us say act.
It means any structure, erection or monument or any tumulus or place of interment or any cave, rock, sculpture, inscription or
Which section you are reading?
Definition section.
Of which law?
Archaeological ancient monuments. Lords. The Karnataka Ancient Monuments and Archaeological Sites and Remains Act 1961. Both it is in Karnataka also and on page number 6.
Page number 319. 319.
It is also in Central Act, my lords. Ancient Monuments and Archaeological Sites and Remains Act 1958. Definition section A.
Which law? Which act?
Ancient Monuments and Archaeological Sites and Remains Act 1958, and also in the Karnataka Ancient Monuments and Archaeological Sites and Remains Act 1961.
First you are referring to which law? First you are referring to central law?
Central.
Which section?
Section 2A.
2A.
Definition. It also includes remains of any ancient monument, sites of ancient monument, such portion of land adjoining the site of ancient monument as may be required for fencing or covering, otherwise preserving such.
So which has been in existence for not less than 100 years.
100 years. So it is more than 100 years.
What is there to show that this?
There is RTI reply, my lords, of archaeology. RTI reply of archaeology, my lords.
Let
It
us-
clear,
Any other document
number
apart from
42.
RTA? Where
my
is that?
lords. Page
This,
number 42, my lords.
Page
42,
42.
yes. The temple complex displays Indo-Islamic architectural features such as arches, kangaroos, and in addition to traditional pillars of Hindu temples, the temple may belong to 17th to 18th century CE period.
So this is located where?
It is in Hidkal Dam, my lords, Belgavi district. The temple is submerged in dam.
It is already submerged.
Yes, my lords.
At which place?
Belgavi district.
Belgavi.
Yes, my lords.
If it is submerged, already submerged, then I'll be
It is accessible in summer, my lords. For 6 months, it is accessible.
for
and-
6 months accessible.
Yes, my lords. And we can relocate this temple. Lords, on page number 47, there is temple
So
structure.
according to what is the way out to protect it?
Yes.
What is the way out to protect it?
My lords, I want to relocate this temple. This is
Relocate it.
Yes, this is constructed with interlocking system. So we can remove those stones and we can
Then
shift
the-
it to
the
other place.
Structure at page
Page 47, my lord.
47, 48. How this can be relocated?
This is constructed with interlocking system, my lords. Interlocking system means stones are interlocked with each other. So we can with cranes we can
Remove and it can reinstalled.
Yes, my lords.
Different place.
It is already done in KRS Dam, my lords. Page number 51.
Page number 50.
Page number
50 is what? 50 is, how can this be
55,
relocated?
my lords.
This,
This is a
This can also
Venugopala
be-
Swami temple.
this can also be relocated.
Yes, my lord.
50, page 50.
55.
No, page 50. It is a building, a kind of,
Yes, my lords. This is same temple.
no, this can be, this part also can be relocated,
Yes, ma'am.
entire.
It is already done in Mysore, my lords, Venugopal Swami temple. Page number
Page
Page
number
number 55, my lords.
55.
This was some 12th century some temple.
This is a relocated,
Yes, ma'am.
different temple.
Yes.
Which temple?
Venugopal Swami temple.
Venugopal Swami.
It is near KRS Dam.
And which provision of the Karnataka Act will apply?
According to the definition, it is an ancient temple, but there is no any particular provision which says about relocation.
No. About Karnataka Act, where is the definition?
Page
Same
number,
definition. Ancient monument, same definition.
Page number 6.
Verbatim, same definition.
Yes,
In Karnataka Act and Central Act definitions are same.
same.
Same. So what is the difference in the Karnataka Act?
This is passed by the state, my lords, but
Let
definition
everybody
is
know.
same. Definition same. Even this also says not less than 100 years are included.
So you are a student of law. Why this? What is the difference between two acts? Any difference is there?
Yes, my lords. Central is act is for all India and state is
That
for
is not-
particular.
That is a too nebulous answer. You find out next time. What is the difference? Is there any difference in provision between the Central Act and Karnataka Act? On the next day, first query will be that. Heard in part in person. The part in person is a student of law. So by filing this petition, it is the case put forth by the petitioner that the Allama Prabhu Swami temple And Vitthal Temple, VAJL.
So, my lords, archaeology has provided wrong information.
So only one temple.
Yes, my lords. Allama Prabhu Swami temples. First temple.
You are yourself saying two temples. Allama Prabhu Swami temple.
But the first temple was surveyed, my lords, because the second temple came after survey.
we are concerned with which temple?
Right now, my lords, first temple
Which one?
for survey, Allama Prabhu Swami temple.
Allama Prabhu Swami temple.
They have provided wrong information in RTI, my
It
lords.
is located in the Hidkal Dam, CDKL Hidkal Dam of Hukkeri Taluka, Belagavi. Is an ancient monument, and that it falls within the and that it satisfies the ingredients of the definition of ancient monument as found in section 2 into bracket A of the Ancient Monuments and Archaeological Sites Remains Act 1958, as well as defined in section 2 small regular 2 into bracket regular 1 of the Karnataka Ancient and Historical Monuments and Archaeological Sites and Remains Act 1961. It is stated that for half of the year, the temple remains submerged in the dam water. Since built in the 17th and 18th century, and satisfying the concept of ancient monuments, and in view of its historical and religious importance, it is pleaded by the petitioner that the temple is required to be declared as archaeological monument and deserves to be registered and treated accordingly. It is further pointed out in the petition that the petitioner has time and again approached the competent authorities to point out the historic, artistic and religious significance of the temple, which is of national importance, to ensure that it is saved from spoliation, disfigurement, destruction, removal, and disposal. However, the authorities have remained inactive. Paragraph. It is the further case of the petitioner that since the temple has been going underwater for certain period during the year, it is required to be relocated. It is also submitted that having regard to the nature of construction and the remains available of the building and the temple site, the entire building could be relocated scientifically to another suitable place. Full stop. Notice returnable on.
Now let's one more point about RTI.
What?
Archaeology has provided wrong information even after multiple requests.
You amend the bill. Notice returnable on 11th November. The respondent department shall file response to the case of the petition. Okay. But you come prepare about the difference of 2A.
Much obliged.
Writ appeal matters, cell number 15, Mr. Raghavendra G. Gayatri, before the appellant.
Case of regularization, delay is there.
Delay is there?
Yes, notice.
21 days. Notice written.
Notice.
20th November.
Please.
Cell number 16, the Pravina Kumari party in person.
Delay is there.
My lord,
Notice written. You are appearing.
Yes, my lord. Respond 1 to 3, my lordship.
You are only, any other respondent is there?
The respond 4 is there, private respond, my lordship.
Notice written on 22nd November.
Number 17.
For the appellant, my lord,
Small
moved the matter during
respondents
vacation.
Which order you are challenging?
Lord, it's against non-grant of an interim order by the single judge, my lord, that we moved the appeal.
Where is the order?
Order, my lord, is adjourned, matter is adjourned to 24th.
So where is the order? There is no order.
There was, my interim prayer, my lord, was deferred. In the meanwhile, my lord, there were steps being taken, my lord, to precipitate the matter. And that is the background in which, my lord, appeal was filed. My lord, it was considered. There is an interim arrangement, my lord, which has been worked out, my lord, which is operating till today. My lord, the only direction that has been issued is that they should not allow, my lord, grant this contract in favor of anybody else. Still, the writ petition is considered, my lord, on the 24th. That's the order, my lord, of 4/10/2024. Writ petition is coming up on 24th, my lord, for consideration. Lord, this is a case, my lord. This is the background, my lord. If my lord permits, my lord, I'll just place this aspect for consideration, my lord.
When this writ appeal was taken up for consideration,
May I?
upon a query put to learned senior advocate Mr. So and so for the appellant as to which order is in the challenge, the only order which could be pointed out was the order figuring at page 30.
Yes, I filed it along with a memo, my lord, because it was not available. There are two orders, my lord. It's just adjourned, my lord. The matter is posted for 24th for consideration.
Where is that order?
4/10/2024 is the order, my lord.
Page?
It's along with a memo of 4/10/2024, page 6. Page 5 and 6.
We don't have a memo.
No, we have given. Oh,
I'm sorry.
Yes. It was filed in open court. Is that anything?
At page 30, which reads as invert comma, relist in fresh matters on 1/10/24, as well as order dated 1/10/24, which says, as well as orders dated 27/9/24 and 1/10/24, which only says that, only repeats to relist the matter on matter lastly on 24/10/24. Therefore, evidently, no order is passed by a single judge, much less any judgment which could be subjected to appeal in the appellate jurisdiction under section 4 of the Karnataka High Court Act 1961. Full stop. It is also not in dispute that the writ petition is at large pending before a single judge to be next posted on 24th of November. Full stop. The only grievance which was raised by learned advocate, which could be raised by learned advocate for the appellant, is that in the meantime, the respondents have been allegedly taking precipitative actions, and that the interim order and the prayer for interim relief is not being considered by a single judge. Full stop. In absence of any order, and in view that the petition is yet to be considered on merits by a single judge, there is no reason for this court to entertain the writ appeal. Full stop. The writ appeal is dismissed only on this ground. Full stop. It will be open for the parties to request a single judge to prepone the date of hearing of the appeal. Full stop. A single judge will give due regard to the request and fix the early date of hearing to consider inter-alia also the prayer for interim relief, which may be made by the appellant petitioner in accordance with law and on merits after hearing both the sides.
Lord, the interim arrangement, my lord, which has been made by the coordinate bench, my lord, let that be continued for 1 week, my lord. I will move the single judge.
Lord, this is a case where.
Full stop. That will we have to continue. Full stop. It was pointed out that by order dated 4/10/24, the coordinate bench has passed order providing for interim arrangement. The same arrangement shall continue to operate till learn a single judge takes up the petition. Full stop. It is our observed that continuation of the interim arrangement as provided in the aforesaid order dated 4/10/24 does not have any reflection on the merits of the case of the either side.
Your Lordship, may kindly not continue. What happens is that here is a party who does not even have the money to complete the project. After the
Not correct, my lord.
1 second, I did not interrupt my learned friend.
Not correct.
After
Don't
the
make false submission.
I don't know why my learned friend wants to interrupt me. He does not want me to speak. After the completion of the tenure of his contract, he moves the writ petition. The tenure is over. It is a case of expiry of the contract.
Something is there, you can let it be. We may post the matter on early date.
Your Lordship, may then kindly fix the date, Sama,
We'll fix the date.
before the learned single judge.
What did you write? The heads of the case, the learned single will take up the petition, including the
16th, my lord, if it's possible.
in accordance to law on 22nd.
16th, if it's possible.
16th?
Yes.
16th.
Great.
Great. So that will be only change. Rest. Appeal is disposed. Interlocutory applications will not survive any of the disposal.
I appear for the appellate.
Commercial appeals, SL number 18, Rakesh Kni.
You wanted time?
Yes.
Why?
I have not paid for any interim order. Notice.
So what is the award? What was the award?
Initially 1,03,000 was awarded, my lord, %. Then it was enhanced to 1,40,000, against which I filed a commercial OS. That has been dismissed. Against that, I have filed this appeal. Property that is acquired is 13 cents, 13.60 cents.
Claim is rejected. When do you want?
Of 2 weeks, maybe.
2 weeks.
This month and 28 or 29th. Month and 28 or 29th.
28.
Yes. Sure.
Notice returnable on. Third law and order will be so and so, so and so, notice returnable on. Seventh November.
Much okay.
Number 19, Sanjay Krishna V.
You have the advocate for the.
And for the appeal, my lord.
Somebody wanted time.
My lord, yes, my lord. My senior is touching down in the afternoon, my lord, from abroad. Kindly, my lord, may I have it in the next week, my lord?
Let me fix a date. On the last several occasions have taken time. Won't insist. Let a date be fixed and we can be done with it.
Next week, my lord, kindly, my lord.
Concurrent decisions against them. I am the claimant. I have succeeded in the arbitration. It's a money recovery claim. Page 125 is the operative portion. As on date, they owe me 25 crores. What I have not received on Naya Paisa. 125. They challenged it in section 34. That also they have failed. Now they stand before this honorable court. This now has come up to with interest to about 25 crores.
Let him have the time. When do you want?
No day.
Any day in the next week, my lords.
Next week.
Yes, my lords.
23rd of.
Much obliged.
23rd, my lord. Great.
Number 20,
Your Lordship, in this paper for the appellant, some technical issue is there. One Mr. Jain Mehta, senior counsel, argued from the Delhi, so he's not able to connect it. Kindly pause over the other.
Pardon?
No, this matter is argued by the senior counsel from Delhi. Some technical issue is there. He's not able to connect it, my Lordship. So
Not
kindly
able to
pause over just to.
22nd. Not 22nd, but 22nd of 22nd October.
Grateful.
Bill number 21. See.
The connected matter.
Number 22. So Dalwai Venkatesh.
Oh.
Respondent, my lord.
You wanted time.
Your lordship, if we could get 1 or 2 days time, my senior was to come today, unfortunately, he's not there. You could just grant 1 or 2 days time.
The money dispute, my lord. Already filed execution petition and date is given for tomorrow in the trial court. 1 crore 90 lakh is due as on today.
Mm.
21st. Twenty-third, not 21st, 23rd. 23rd.
Bill number 23. Vishwanath Shetty.
Appellant.
Respondent. But one
appeal
submission
by
is,
the-
I have a preliminary objection with regard to maintainability of this appeal. This company itself is no longer in existence. The name of the company is struck off from the registrar of company. And that is the finding given by the lower court also.
My lord, so far, that aspect concerned, my lord. My appeal before the NCLT is pending, my lords, please. And before ROC also, we have moved, the matter is pending. My lord, the very jurisdiction of the honorable trial court is required for consideration of my lords, whether the judgment passed by the honorable trial court will sustain is a point for consideration. As the land in question is an agricultural land, my lords, please, which in pursuance of an MOU for entering into a future joint development agreement for development of the property, permitting me, the plaintiff, to convert the land into non-agricultural purposes and thereafter to utilize the same for construction, my lord. So the point of very,
What is pending before NCLT?
please, my lord.
Nothing is there on NCLT. Order is passed by the registrar of company under section 248(5), saying that the company's name is struck off. No finances, no transactions are being done in the name of the company. That is a finding at page 191 of the trial court's order, page 191.
A copy of the proceedings initiated before the NCLT.
Para 175, page 191. And 176 is the finding.
Where is the prayer, suit prayer? Prayer in the suit.
Prayer is blood to
Recovery.
execute another JDA. That is
Page.
page blood.
Plaint is produced, my lord, which commences in page number 226. Then, my lord, the prayer can be seen from page number 246 to the appeal memo.
Page 245, last paragraph.
Yes.
Please,
Specific performance of the MOU, directing defendants to execute regular JDA. So it is a contract to execute another contract. Supreme Court has held, my lord, such a petition suit is also not maintainable. That is not for execution of the sale deed. Judgment copy.
We'll admit and fix the hearing.
But there is an order saying that I should not alienate. Now, the prima facie, the appeal itself is not maintainable.
my lord.
Because
Mainly,
once
the honorable-
NCLT succeeds, then only he can seek to file this. As on things stand, there is no company at all in existence. MOU is executed by private persons. Company was not in the picture. Thereafter, company files the suit. Company also, the name is struck off by the registrar of company.
But that notice by the register of company is under challenge.
So this registrar of companies passed an order under section 248 of the Companies Act, striking off from the register of the companies. Now he, my learned friend, says that he has.
That order is under challenge?
It is
That
in
order is
appeal.
there.
Appeal.
I'm filing.
No, now he says that he is under challenge, but that has to, unless that appeal is allowed, company is not in existence, there is no stay order also.
My lords, kindly, some interstate dispute was there between the partners. So that order came to be passed by
And
the
how will he develop?
competent authority. My lord, even the question is that mainly, my lords, please, whether the honorable trial court had jurisdiction to entertain the suit, my lord, because the land in person was not a converted land.
He does not produce the appeal copy also. He only says produces the endorsement.
I'll place it, my lord, I'll place it immediately.
This
And-
Messrs. Whitefield Shelters Limited is not on the roll of the company.
No, that is the order, my lord, which your lordship should get it at page 190.
My lord, those aspects can be taken into consideration for final
Kindly
reading,
see
my lord.
page 190,
Firstly,
lord.
Whether this honorable trial court is having jurisdiction to entertain
page
this suit.
191, para 175. But to prove the above said fact, plaintiff has not produced any supportive documents before this court. On the other hand, to prove the said contention of the defendant have relied upon document at exhibit D4. On perusal of contents exhibit D4, Xerox copy of notice, it shows that on 22/3/2019, not today, my lord, Registrar of Companies Hyderabad has issued the said notice to plaintiff company, wherein it is clearly mentioned, this is with respect to this office notice dated 6/8/2000 notice so and so. Notice is hereby published that pursuant to subsection 5 of section 248 of the Companies Act, name of Whitefield Shelters Private Limited has this day of March has been struck off the registrar of companies and the company is dissolved. Then, my lord, para 176. Considering the above facts, looking to the contents of the notice, I am of the opinion that during pendency of the suit itself, plaintiff company was dissolved and also name of plaintiff company was removed from the list of companies by the concerned authorities. On the other hand, on perusal of the evidence of PW1, it shows PW1 has stated in his evidence that in respect of the said fact, they have intimated their auditor to file necessary application before competent authority. On perusal of entire documents produced by the plaintiff, it shows that plaintiff has not produced any proper document to show that by challenging the above said order of registrar of companies, plaintiff has filed the application before competent authority. Till today, the said order passed by ROC is set aside by any of the competent authority. Now, without referring to any of this, without explaining it, this very same company files the appeal. And the MOU which they are seeking to execute, my lord, is not with reference to the company at all. It is by some private person. And the court also says they don't have the financial capacity to develop the land because the
So the-
company doesn't have any finances.
Specific performance was sought by the appellant.
Yes, my lord, he says that I will develop your property, give you one portion and that, but
My lord, I placed the documents that I am able to proceed with
But
the.
no more, that's the whole thing.
No, it is by the company, my lord. Plaint is presented by the
So
company.
that plaintiff
It's
is
a
no,
company.
company is not registered.
My lord, that aspects concerned, the matter is pending as on today. My lord.
It
It
is-
is only due to interstate dispute between the partners. My lord, only one partner was,
It has lost its legal identity
please, my lord.
and the status
Ma-
as legal entity.
My humble submission, my lord, even for that aspect also, I'll convince short accommodation may kindly be granted. And moreover, my lord, maintainability of the suit before the honorable commercial court is point is
Now you
there.
tell us you are representing whom?
My lords, please, I am representing to the company only.
Where is the
because
company?
Is two partners who have filed the. Is two partners. My lord. Now appeal is pending, my lords. Please.
Where?
It is a continuity of proceedings, my lord,
Appeal is pending.
before NCLT. my lords.
No appeal.
Appeal against which
2020.
order?
Appeal memo I'll place, my lord.
Appeal against which order?
Please, my lord.
Appeal is pending against which order?
My lord, one of the partner who is the reason for this resolution.
Nothing to do with.
My lord, kindly grant me a week's time, my lord. Convince on that point also. My lord.
We'll take up on 22nd.
Very well.
22nd.
Please.
22nd at 2:30. The suit is dismissed on that ground only.
Suit is dismissed among other
On
grounds. This
that,
is also one.
on that ground alone.
On that ground also, apart from other grounds.
So you
But
make
kindly-
your case good.
On 23rd, my lord, if possible.
23rd.
because 22nd is inconvenient.
23rd.
Please.
I'm taking now, continue whatever. Last time we had given an undertaking, will not alienate on because my learned friend wanted some
Like
time.
that order was operating from the date of it.
But that undertaking.
For
Lord,
another
I
1
don't
week,
want
it
to
would not be.
because
It is recorded.
It is recorded on that date, with the first day, my lord, when the matter came up.
The undertaking which is recorded earlier by the court shall continue to operate till the next date since the
Next date, my lord, I will not continue.
learned advocate. The next date.
I thought I will say that I will not continue the undertaking, but anyhow.
Once it is to be heard, final. Yes.
So, number 24, YP Gokul for the appellant, your lordship.
Your lordship, I appear for the respondent number 1. Your lordship, may I request for a short accommodation, your lordship? My colleague had made a mention in the matter. We have informed the appellant counsel as well. It can be taken up any date next week, your lordship.
My only submission is they should not precipitate the matter before the trial court.
I want to file objections for the application for a stay, your lordship, for the reason that, your lordship, this matter was heard earlier by this honorable court, and this honorable court had directed the appellant to deposit the amount, your lordship, of the decree. But because they had not done, I was permitted to file objections. I received the IA on Friday, your lordship. If I may be given 2 days, 2 to 3 days time to file objections to the application, your lordship.
A conditional order may be passed. I am prepared to deposit staying the impugned judgment and decree.
There is no stay. Why do you?
Yeah. Lordship, I am
You are for appellant.
appellant, please.
There is no stay. Whenever you want.
Lordship, I am prepared to deposit the amount. The matter may be,
They want time.
please.
You are prepared to deposit the amount, entire, bound to be. Money decree. If you are seeking stay, then you're bound to deposit. We'll consider on 23rd.
On 23rd, your lordship, please.
Obliged, your lordship.
Certain tender conditions are violated.
Your lordship, the court mic is muted, your lordship.
20. 23rd.
Please. Arbitration matters, seal number 25, Mr. Anumant Reddy.
Appearing for the appellant, my lord. I'm seeking a
Point
short
number
extension of 2 weeks, my lord. Please, my
Why
lord.
everybody is seeking time?
My lord, regarding the relevant documents have been sought from the office of the competent authority, my lord. In that regard.
So 25th of October.
Please, my lord. Grateful.
The complaints in contempt matters, seal number 26, the Ravi Shankar K.
My lord, I appeared for A1, my lord. I have filed my reply statement.
Lord, I'm for the complainants. Earlier occasion, accused number 2 has filed an objection by stating the complainant was above age. But in this regard, they have not given any supportive notification or gazette notification order. So I pray, my lords. Short accommodation.
Lords,
to file my
notification is available. Above 40 years, we cannot take for grade C employment.
My lord, in my reply statement, I have filed a communication to the complainant.
And my lords, we were not party to the writ petition.
Page 15 are the directions. Where are the directions?
Page 15.
You're not ready?
No, ma'am. One
Let
short.
it go to December then, if not ready, 16th of December. Be ready and come. Don't waste it. Just next.
Seal number 27. Shirish Krishna.
Appearing for the accused, my lord.
Lords, for complainant.
Yes.
Though, my lord, the state says that, my lord, they have complied with it. My respectful submission is that, my lord, it is not so. Probably there is an effort, my lords, to misrepresent and mislead, my lord, this honorable court. My lord, the grievance of the complainant is that, my lord, direction came to be issued. Annexure A, my lords, page number 14, my lord, the order of division bench of this honorable court.
Page 20, 19.
My lords,
Cooperative
page number
portion
20 of the writ petition, my lords, may. 20 of the contempt petition.
Yes, what happened?
My lord, here the question is about absorption. We have filed 2 affidavits, my lord. And what has happened is we have also the governing council has taken a decision that he has to be repatriated and absorption would not be possible in view of the rules.
That is no answer.
My lord, I would like to place my detailed affidavit as to how the learned appellant herein is not entitled to the absorption.
So any decision is taken?
Yes, my lord, there is a GC report which has been filed, which has not been filed. The GC report is dated 18/6/24.
So you are communicated in decision?
My lords, that's the reason, my lords, I said probably there is an effort, my lords, by the other side. My lords, specific directions were, my lords, to consider and take a decision, communicate within 1 month. My lords, the state, my lords, in fact, issues me an endorsement. My lords, I have filed, my lords, further pleadings, my lords, that is an affidavit counter to, my lords, what the other side has filed, my lords, on 1st of October. The state comes up, my lords, immediately with an endorsement at page number 21, my lord, the Kannada version, and 24, my lord, the translated version.
My lord, the entire case has a checkered history. In fact,
I'll take only 2 minutes.
please.
'24 and '25, my lord, the English version, my lords, is placed. They say we have absorbed, my lords, page number 25.
So a reabsorbed is an assistant professor.
They say it is done, but they don't pass any orders. My lord, this was on 12/5/2020. What happens thereafter? My lords, in 2022, my lords, by annexure E, I have placed, my lord, the resolution of the governing council. Governing, my lord, the translation, my lords, is at page number 31, my lords.
Subject 12.
Please,
Subject 12.
my lords, what happens is, my
No,
lords,
subject,
there,
13. Dr. Leela.
page number 34, my lord, the last paragraph, if lordship kindly see. Lord, they say retrospective absorption is not possible, but retrospective absorption should be made in accordance with rules. Matter is placed before, my lord, the vice chair, that is vice chairman, the honorable Minister for Medical Education. He passes an order, page number 37, my lords. The legible copy, my lords, at page number 39. He says, my lord, since the absorption is confirmed, she may be continued in INU. As far as seniority is concerned, the existing bylaw should be applied. That is approved by, my lords, the then Honorable Chief Minister also, who happens to be the chairman of, my lords, the governing council. But they don't issue any order fixing the date of absorption. They keep the things as it is. But later on, my lords, they come with a resolution saying that I am senior to, my lords, another private person. He challenges that, my lords, before this honorable court, my lords, page number 40. Learned single judge holds, since I have not issued with any order of absorption, it cannot be construed that I am absorbed. And he says she continues to be the employee of Health and Family Welfare Department. My lords, if it's a fact that, my lords, these resolutions and, my lords, the endorsements were not considered by the learned single judge, and the matter is in appeal now, my lords, before another division bench of this honorable court. But fact remains is I suffered an order saying that I am not the employee of the institute, in spite of the fact that, my lord, there's a direction, there was an endorsement, and, my lords, a resolution pursuant to which an order was also passed, my lords, by the concerned authorities. Lord,
Yeah, what is page 39?
Lord, 39, my lords, is what happens, my lords, is if I pointed to your lordships, page number 34, the governing council resolution, not the relevant paragraph, it starts at page number 31. 34, last paragraph. My lords.
My lord, my instructions.
So then writ appeal will decide the fate of this.
My lord, let me submit this. My lord, the writ appeal which is there is, my lords, insofar as the challenge to the order of the learned single judge. who has passed the order saying that I'm not the employee of the institute at all, after the order of the division bench of this honorable court, whereby my earlier absorption was set aside. He says no order has been passed in my favor. Fact remains that there were orders, my lord, that is brought to the notice of the division bench now. In the meanwhile, my lords, I filed a writ petition also before this honorable court, my lords.
Whatever is decided in the writ appeal of 23 will have bearing in this on aspect.
My lords, that is
My lord, what is-
2020, my lords, the order, the annexure A. My lords, it is in pursuance of that only. What the state has not done. Specific direction was issued to, my lords, communicate the decision. My lord, they have to say from which date the absorption comes into effect. Deliberately, they have withheld it.
My
In
lord,
fact, because of that, what is happening is, my lords, now I am being branded as an employee, my lords, of health and family welfare. In spite of, my lords, factually, they say that I have been absorbed. Now, my lords, they pass another resolution. The governing council passes a resolution without reference to any of the earlier proceeding and says, you are being repatriated to the parent party as no decision is taken.
The governing council order, my lord, which is of 18/6, specifies as to what has transpired. My lord, it is in Kannada. I will get the translated version and place it before your lordship. However, my lord, in this case, what has happened? The order which is against which the contempt is filed is to consider for absorption in accordance with law. Now, my lord, when it came to be considered by the GC, the seniority of the appellate, complainant herein, my lord, was reduced because there was another person who also sought for absorption. She did not accept the absorption given at that point of time and now comes before your lordship in the contempt, stating that we haven't given any absorption order. The absorption was given, which she denied, my lord. That has been reiterated and detailed in the governing council meeting, which happened on 18/6/2024. My lord, I would like to place that governing council meeting for this honorable court. It is in Kannada. And therefore, my lord, the complainant herein can challenge that. In fact, that has also been challenged. There is a series of writ petitions and writ appeals which the complainant has filed.
Merely for the reason that they have not complied with, my lord, the order of the division
Compliance
bench.
comes in.
If they comply with, my lords, all the litigations can be put to an end.
My
Lord, they want
submission-
to keep the issue, my lord, for the sake of, my lord, someone else. My lord, they want to keep the issue alive. They could have decided, my lords, by issuing an order, my lords, in pursuance of the order of division bench of this honorable court. My lord, the issue is this. I was absorbed earlier, my lords, no doubt. I was absorbed with another.
The writ appeal pending.
My lords, the writ appeal insofar as, my lord, the produced, my lord, the case stated is also, my lord.
Is against which order? Same
My
order?
lord, the order at annexure G, my lords. My lords, the complaint is against, my lord, the present petition is against, my lord, the order of the division bench of this honorable court, where a specific order was given insofar as taking a decision is concerned.
In fact, we have also filed a status report wherein this GC order has been stayed. And ultimately, it is for the GC to decide, and the chairperson and the committee of the governing council.
Direction was issued to the government, my lords, by division bench of this honorable court. They cannot, my lords, shift the burden, my lords, to the GC, my lords. If lords kindly see annexure A order,
The decision shall be taken by the state government in accordance with law.
and
In
communicate.
accordance with law is the GC is the ultimate
Without-
authority.
Without reference to 12/5/2020, my lords, the endorsement is showed and subsequent GC.
But we will have to await the outcome of.
My
When
lord,
appeal is going to be listed.
My lords,
sorry, there's no date given in that.
date
matter.
is, my lords,
The last date was 30th, my lord.
my lords, on 24/10, my lords, the date is given.
24/10.
Yes, my lord.
It was stated that a writ appeal connecting to the subject matter is slated to be listed on 24th October 2024, the outcome of which may have the bearing on this contempt proceedings. In that we put up on 7th November.
Published.
Much obliged.
Are you okay for the complainants, my lord? They have complied with the orders, my lord.
Complied with Law and Advocate Miss. What is your name? So and so for Law and Advocate Miss so and so who complain makes a statement that the order under contempt is complied with. Post of Law and Additional Government Advocate Miss Pramodini, which confirms the statement about the compliance of the order of Law and a single judge in the aforesaid view. The present petition under the Contempt of Courts Act 1971 no more survives. It is accordingly disposed of.
I'm appearing for complainant, my lords. They have not served the compliance affidavit, my lord. For my instruction is that the order has not been complied, my lord.
We have complied the order, my lords, totally complied.
It is for reinstatement and monetary benefit.
We have.
See it.
My lords, I'll file rejoinder, my lord. It
As
is
per
not
the order
complied,
of
my
Law
lord.
and a single judge dated so and so.
I'm entitled for
Pardon?
50% of
Chin
monetary
bench order.
benefits, my lord.
Dated 18 July 23, the petitioner was to be reinstated with 100% pay credits.
No.
It is
They
this
have
order
not
which
paid
brought
the arrears of
the
salary also.
contempt
my lord.
jurisdiction for its alleged non-compliance. Paragraph. When the petition came up for consideration today, learned additional government advocate Ms. Pramodini Kishan filed compliance affidavit
Yes.
which reflected spectrum of reinstatement of the petitioner as well as payment of back wages. Also,
My lord, there is no monetary benefits, my lord. They have not paid the monetary benefits.
That's, the order says that 50% of the monetary benefits, if it is paid, if the order is passed within 15 days. And I filed the affidavit to show that we have passed the order within 15 days and we have paid 50% of the monetary benefits. Paragraph 7 of the order, my lords, page 33.
it's silly.
My lord, I'm requesting for one date, my lord. I'll just take instructions, my lord. My instruction is that it is not complied, my lord. They have not paid the 50% till date. I'm requesting for one date, my lord.
Where is your affidavit?
Lords, affidavit has been filed on 3rd September 24th.
They have served the affidavit now, my lord. I'm requesting for one date.
1 second. Third, yes, 3rd September. So when the petition was reinstated,
16/8/2023,
16/8/23.
my lord.
then
16/8/2023.
beyond 15 days,
Lords,
Please.
they are from the date of receipt of the order.
date of receipt of.
And I have filed the acknowledgement for us having received it on 4/8/2023 minutes. Annexure R1.
Next, sir, R1.
My lord, it is from the date of this order, my lord. Kindly take page 34, my lord.
Date of.
33 and 34. May I read, my lord?
Right. 43.
Para 7.
On the date of receipt of the certified copy.
In 34, my lord. In the event the petitioner does not reinstate the first respondent within 15 days, the petitioner shall be liable to pay 100% of service benefits
Where is your
together with interest
where is
to be
your
calculated from the date of this order.
the
last line.
100% back wages.
Please,
If payable, if you are not reinstated within 15.
within 15 days. It is
And-
beyond 15 days, my lord, 16/8/2023.
Your endorsement.
Lots, R1 is the date that we received the order.
Page.
Page 4, my lords, of the affidavit.
Page 4 will be.
Lords may kindly see the date, my lords. 4/8/23 is what we have received.
4/8, yes.
Please.
That is
And
late.
the order, my lords, is at annexure R2, which
This
is at
4/8
page.
is what? How do we know that this is the date of receipt of the order? 4/8.
Lords, this is the acknowledgement, my lords.
This is an acknowledgement.
My
of
lords,
the
the
order.
number also is there.
Your own
The,
order.
for having received the number, the Tapal number, my lords.
So you passed the order before the receipt of the order,
Yes,
2nd August.
60.
Date of order is 2nd August.
2nd August, and we have received it on 4th August.
How can it?
Plus, the government advocate has sent the order. That is the letter, my lords, enclosing.
Lords, I'm requesting for one date.
They are ahead of time. No, why we should we?
My lord, it is not I'll file rejoinder, my lord.
No.
I'm requesting for one date, my lord.
Not a matter to be given time.
My lord, it is not complied, my lord.
It is
I'm
compliant.
sorry.
You are reinstated or not?
I'm reinstated, but they have not paid the monetary benefits, my lord, till date.
Not payable.
The direction is for payment of monetary benefits also, my lord. Reinstatement and monetary benefits.
The order is made for 50% of the monetary benefits because it is within 15 days. The translated copy is on.
You read he is right. You read the paragraph 7. Read paragraph 7. Page 30.
Page 33.
Page 30.
30 of the order.
Impugn order. You have paid 50% of the way.
Please,
Paid.
we have, yes, my lords,
50% is paid.
50%.
My lord, they have not
Monetary.
paid, my lord. It is order passed, my lord, but they have not paid. And I'm entitled for promotion also and time-bound increment.
And we are concerned with reinstated and 50% back.
Please.
And if not reinstated within 15 days, 100% back.
100%. I'm entitled for 100%, my lord. It is
You have
beyond.
paid 50% or not?
Order is passed, my lord, but till date I have not received the.
Then nothing survives.
My lord, I'm requesting for one date, my lord. My senior will appear, my lord. Kindly one date, my lord.
No. Senior is, who is senior? Who is your senior?
Satish K, my lord. I'm requesting for one date, my lord. It may be tomorrow, my lord.
Tomorrow at 2:30.
Please, my lord.
Number 30.
For the petitioner, my lord. My lord, the matter pertains to non-provision of facilities to the Badgi residents, the town residents. My lords had directed them to file a report on the last occasion. They filed a report. And as per the report, they say they'll provide the facilities once respondent number 4, which is a PWD department, asphalts the road. So it's an admission that amenities are not provided. They filed a report on 27th September, my lord.
Where is the report?
27.
2799.
Filed by the respondent number 2, the municipal authority.
Yes, so it is not satisfactory.
No, my lord. If I could take my lords to paragraph 1 of their report, where they themselves admit, but fourth line from the top, my lord, the further statement that the photographs produced by respondent number 2 discloses that part of the Badgi main road is still not asphalted is correct.
In this context, it is relevant to state that the asphalting of Badgi Main Road is within the domain of respondent number 4, as the said main road is state highway number so-and-so, which is Gajendra Ghatkar Soraba High State Highway. Then about 5 lines below, my lord, as such, respondent number 4 could not be able to asphalt the main road in view of the pendency of the writ petition, which came to be allowed by order dated 19/10/2022. My lords have it. Yes, my lord. From the bottom, about 5 lines, my lord. As such, the respondent number 4 could not be able to asphalt the main road in view of pendency of writ petition, which came to be allowed by order dated 19/10/2022, quashing the said notification and giving liberty to redo the same after following procedure contemplated therein. Then, my lord, the next page, they rely on an order of the Honorable High Court, supposedly which prevents them from undertaking any work. They've produced the order. I'll take my lords to that order. They say, if I could just trouble my lords to look at the paragraph. Accordingly, this honorable court was pleased to issue an interim order not to take coercive steps till the next date of hearing by order dated so-and-so. Then they say, on account of such interim order passed by the Honorable High Court of Karnataka bench at Dharwad, respondent number 4 has not completed formation of Badgi Main Road and adjacent drains, which is the subject matter of the writ petition. As such, the formation of main road and drain work on both sides is stalled. With due respect, my lord, the writ petition they're referring to challenges the acquisition order that has been passed, which they have themselves produced. And they say there will be no coercive steps taken in respect of that writ petition's landowners. It does not say roads will not be formed, drains will not be provided, gutters will not be closed. If I could take my lords to their order at page 18 of the same affidavit, my lord. 1/8, my lord, page 18.
My objection statement. My objection statement, page 18.
My lords have it. Page 18, the order is dated 7/9/2023, my lord. My lords have the order.
So notification under which act?
My lord,
This notification referred to is under which act?
this is with regard to the land acquisition,
Land Act.
my lord, not with regard to formation of roads or otherwise. They, both respondent 2 and respondent 4 are passing the ball to each other saying,
The road, land forming part of the land is required.
yes, my lord. That land acquisition notification has been stayed. Now stayed. According to this particular order, they've said no coercive steps will be taken against the landowners. Now they're using that to come before this court and saying that we are not going to asphalt the roads. We're not going to provide drains.
Yes.
But it's a state highway. It is a state highway, CH-136 from Soraba to Gajendragarh, which is passing through the main city. On account of the persons of their choice, they are in the habit of filing the writ petition and getting the interim order before the High Court bench and stalling the work. We have made a lot of correspondence and PWD has acted upon. And the funds have been, attempts have been made to release the funds. And day-to-day work that we are carrying out, we have maintained. I have produced the photographs on 27/9.
You are chief officer.
I am the chief officer.
You don't understand the law and implications of law. What that stay has what to do with this repairing of the road?
Well, I have carried out the work, day-to-day work, and we have maintained the gutters and the formation of sewerage and water line and other civic amenities. Except the formation of the road, the formation of the main road, that their grievances on them on account of, the PWD has to do their job. Then I have to provide the basic
amenities depending upon the formation of the road and maintaining and the repairing work is of the municipality.
But your defense is something else in your reply. So this page, this 27/9/29 affidavit is by you,
Please,
which was read out by the council, by learned council. It is by you. Number 2.
Yes,
You are number 2.
yes.
I'm
Chief officer. Read it, let us read it. What you are saying. Yes, sir, the name is not expired on account of the interim orders passed by the High Court in Karnataka bench, so and so, so and so, in the writ petition number so and so, bench of petition. This has nothing to do with your non-expiry.
but if PWD, I have made a lot of correspondence requesting the PWD.
We want this statement made before the court on oath to be explained by you. It is a job of PWD, is a different thing. But you are taking a dishonest defense, then we'll call upon you to remain personally present.
Not necessarily. I will explain under what circumstances this came to
The
be made.
court's proceedings are not only about the merits of the matter,
Please,
also about the conduct of the parties. So are you going to explain this? Or your officer will remain present personally to face the contempt? How can we raise such a defense with this proceeding nothing to do with the asphalting of the road?
but as such, there is no such interim order stopping the work, but only,
Advise accordingly.
sorry for that. I'm sorry for making.
Sorry is not, we are not talking in our house. This is a professional proceedings. Saying sorry in the course of the hearing is nothing. You remedy this situation. Instruct your client accordingly. They come on 21st.
Please.
It is for. My brother is right. Photographs also shows that nothing is done.
But except making that repair, I have produced the photographs
Yeah.
along with the objection statement.
It's page 9 of the
It commences from, please, 8.
page 9.
Yes,
Eight,
my lord.
nine.
That merely shows garbage collection.
This is a road garbage collection.
10 shows the state of the road, my lord. 10,
And it is your
11.
statutory duty under the law
12.
to maintain the civic amenities.
But they are every day,
You come with the concrete thing, what you are doing. If you are doing or PW doing, but you remedy the situation created by yourself. Come on 21st. Otherwise on 22nd, the officer will be here.
But I will do that.
Unless on 21st satisfactory remedial steps are not taken. On 22nd, the officer will be here at 11.
Certainly, I will ask them to do.
10 to 21st of October, on which date the council for
Or could it be
chief
on-
officer shall apprise the court about the remedial steps taken in
But could it be
compliance
on-
of the statutory duty to maintain the asphalt road of the city.
Yes, ma'am.
or could it
If
be
you are
on
ready.
29th? 29th.
Hmm?
29th.
No. 21st is also far out. Today is what date? 14. 10 days are going to, 9
Um,
days.
PWD has to come to my rescue in forming the road, main road. But I am not the only
So
person.
the steps taken by you.
But I have produced the correspondence that I have made, annexure. Along with the objection statement, I have produced the letters corresponding to release the funds. Annexures R6, it is in Kannada, annexure R6 to R9. 29. It commences from 20, page 20, annexure R6. These are the correspondence that I have made with them. My lord, on the basis of
Where is that correspondence?
page 20,
Page?
page 20.
Let us. What correspondence? What is this correspondence?
For releasing the funds so as to form the road.
No. Now face an order. Full stop. Order was passed by this court on 24/9. Now face an order.
My lord, I will certainly do that on or before the lordship may.
So when we say that we'll do this, you start arguing. Same order earlier.
Number 31. To N. Shreyas, party in person. Number 31.
That voice announcement. Who appears for? What is this audio announcement? This come?
Hearing impaired and for the.
So you announce the destination wherever the bus reaches. Why are you discontinuing? Take instruction. 25th of October. The 28th of October.
Number 32. Mohammed Tahir.
For the petitioner. I filed application for the restoration of the petition, Lordship, which was dismissed for non-prosecution on 22/6/2023. I filed application to recall the order of dismissal for non-prosecution, Lordship. On that particular day, Lordship, I was.
By filing the present application, petitioner is free to restore the writ petition which was dismissed for want of prosecution as per order dated 22/6/2023.
The reason of my absence is on page number 4, Lordship, para number 4.
The reason stated in paragraph 4 of the supporting affidavit. Makes out a ground. In view of the same, as well as in view that a litigant should be allowed to contest his case on merits rather than being thrown out on technical consideration. The present application is allowed. Writ petition number so and so is restored to its original file, along with all the orders which may be subsisting in the petition. Application.
I request for the date because the writ of mandamus seeking an order against.
The registry may list the petition after 2 weeks.
Number 33. Study in Average.
Appearing for the respondent number 5, 6, and 7.
This is for amendment.
It's a mandamus against the respondents. It's pertaining to a stone crushing unit, your lordship.
Nobody is there. Keep back. Keep back.
Uh,
Keep back.
Yes, and for the petitioners in this case, ma'am. My lord, with
Hearing for
regard to
the respondents.
with regard to the impleading application, I have to file objection, my lord. With regard to the interim prayer is concerned, my lord, the last occasion this Honorable Court was pleased to pass an order to consider the interim order on 39/2000.
My lord, there are no bona fides in filing this writ petition, my lord.
My lord, the forest departments are giving permission to persons who are not entitled to cut the trees by violating the full court and as well as the division bench of this honorable court, my lord. They have been continuously giving permission to fell trees, whereas the owners of the land are not the occupants of the land. They are not the owners of the land in respect of the Bane land and Jamma land and Umbli and other Jagir lands, my lord. I produced the full court judgment of this honorable court in annexure C at page
Reply
90,
will
my
you
lord.
have?
My lord,
Reply is fine.
no, my lord, it's come up because my lord wanted to know whether the submissions made by the petitioner was right. My lord, what has happened is, my lord, the owners of Coffee Estate, my lord, they have filed applications seeking for, my lord, felling of certain trees because of the overshadow, my lord, that was being provided to the coffee plants. My lord, they wanted that to be pruned. My lord, those applications had been filed 1.5, 2 years back. My lord, the forest department has considered those applications are very,
Place on record.
very.
My lord, let there be a direction to
My
the comment
application-
advocate.
Lord, this is,
My-
there are
my-
no bona fides.
My lord,
This is nothing
my
but
learned friend is
extortion.
arguing against the
Let him produce.
own statement made before this division bench and
Let
yes,
him produce.
yes, and my
Very
lord,
well.
I request your lordship to kindly direct the government advocate to furnish all the documents, how many orders has been given for felling of the trees already given and what
Lord,
are the
he's
pending?
He's confused about the whole petition.
My lord,
Completely applicants are the
your
ones
lordship,
who have
kindly I
sought
request,
for, but not
your
felling
lordship,
of trees.
Whatever they want to produce, they will produce.
yes, my lord,
You are for whom?
I am appealing for the Planters Association.
my lord, I have to
Address
file my
association.
objection to
The-
let
the-
it senior
the
friends of.
Planters Association was established in 1879.
You want to be party or you are already party?
Party respondent, my lord, because
Your
I will be
party-
affected with his prayer. My vested rights will be taken away.
You are for, where is your application?
I have made an application, my lord, in
One of 24.
27/9,
1 of 24, my lord.
1 of 24.
That application may be allowed.
Planters Association.
Yes.
No, I have to file my objection.
Why?
We make
How the
application
government
before
can
the
say that
authority.
allowed and all, because I
Under the
have filed my
provisions of the Act.
petition. Because I have got a
Karnataka
serious
Tribunal-
objection for this impleading
We
application.
make contribution.
Sorry.
How you are affected?
My lord,
How you're
in the
interested?
prayer, my lord, they see all that our rights has to be denuded. This cannot be, my lord. For years and centuries, we are using our property, private property, where we grow coffee and other plantations, my lord.
What is his prayer?
His prayer, my lord,
My
to
lord,
denude our, my lord, it's a very lengthy prayer, my lord.
my lord, I may be permitted to read the prayers, my lord.
Not to issue permission to cut trees in forest land, government lands, Western Ghats, and granted holders of the land.
My lord, the permission that is sought for, my lord, is by the owners of the estate, my lord. It's not pertaining to the government land. It doesn't pertain to, my lord, the forest land, nothing. Estate owners have filed these applications seeking for
Granted
ruling
hold,
cutting.
granted hold,
my lord.
Sabane land,
Lords may kindly,
Jamma Jagir and
your
Umbre
lords may
land.
kindly appreciate,
Issues
They are the
the
owners of the
issue.
property.
they are acting against the,
On the coffee estate.
my lord,
Where
similar issue
by
has
virtue-
been
by
taken
virtue
up
of
by
this
this honorable
case,
court in the full bench as well as in the division bench of this honorable court,
My
my lord.
rights have been taken.
In that, their rights has been denied,
You file your reply.
I will, my lord.
my lord,
Which date?
My lord,
When do you-
my lord may give me 2 weeks' time, my lord.
my lord, before that, my lord, I may be permitted to read two annexes, my lord, how they acted in violation again of the
Lord, there is no
full bench as well as the
violation,
division
nothing, my
bench
lord.
of this honorable court, whereas the deputy commissioner and revenue department has given the state report stating that that cannot be permission cannot be granted, whereas the respondent number 5, the deputy conservator forest has given the permission, my lord, in violation of the very.
My lord,
But
bench.
permission given to whom? He's not made them as parties.
No, not necessary. This is a public interest litigation.
Public
That is what my
interest litigation,
lord,
we cannot go around
my
the court
request
and say,
before
why
your
not
lordship
serve
is
the
that
time of
the
public-
government advocate
under the-
filed how many permission has been given, how many applications are pending, and how many of the trees has been fell and cut and converted into timbers, my lord. Because, my lord, it is a public interest litigation. If this permission is given the same manner, this will lead to why not situation, my lord.
Why not situation
Under-
was a
under the
natural
garden-
calamity.
They are spoiling the entire Coorg, my lord, Kodagu district. The way in which they are giving the permission, tomorrow Coorg will not be there. That will become desert, my lord. Your lordship is very well aware that from Coorg, my lord, drinking water from Talakaveri to this KRS, the drinking water to the entire almost 60% of the Bangalore drinking water, Mandya, Maddur, Mysore, and as well as to the neighboring state. This rate in which they are giving the permission to cut the trees, my lord, then after few years, my lord, this will become desert. Not only our state, in the neighboring state also depends upon the rain, my lord, rainwater from Kaveri, Talakaveri.
My lord.
And they are in violation of all the laws, my lord. This is a full court judgment. I may be permitted to read the judgments of this honorable court, where the similar issue has been raised, and the court has denied to cut the trees, my lord. And there are wherein the division bench of this honorable court has imposed cost on the forest department also. In the next date of hearing, I produce all the documents, my lord, to establish before this honorable court.
My lord, if
This is a timber mafia is going on, my lord. Beyond this timber mafia, they are trying to vanish the Kodagu district, my lord. Beyond this, some of the politicians are involved.
May I make one submission, my lord?
He argued before adjournment. You argue after adjournment.
Sorry, my lord. Sorry, my lord.
My lord,
I'm
my
seeking for the
application-
interim order,
my
my lord. That
application,
is
my
the
lord.
reason I'm
application. my
seeking
lord,
for the interim
impleading.
order.
Yes.
All said and done, my lord, as fairness, he should have impleaded me by himself. But.
No, my
they
lord, it's
have
a
come
public
up before
interest
the court.
litigation. I cannot implead each and every person, my lord.
Sir, it
I will
is in-
demonstrate before this honorable court in the, I will file my objection to the impleading application, my lord. Then I will demonstrate how
This
the
is-
impleading applicant is not a necessary party. And what is his status and all. That I will demonstrate before this lordship.
He challenges my property right. And he says, what is my locus?
My lord, in Kodagu district, my lord, we are not having a ownership right. The full court judgment has categorically stated that we are only occupants. We can
Probably, my lord. You
can use the land, you
They got
can.
the full court judgment also, my lord. Because I was handling all these matters as a government entity for a long
Additional
time.
government advocate, Srimati Nilofer Akbar shall file reply with reference to what is observed in paragraph 5 of order dated 23/9/24, as well as in general to the controversy involved in the petition.
The application.
My lord,
For the next day, extend over to 5th of November.
Oblige.
My
my
lord,
lord,
my application,
my
my
lord.
lord, my application.
My lord, one
IAS shall
request,
be-
my lord.
Please,
Let
please.
there be a direction to the government to produce the documents, my lord, how many permission
allowed,
has
my
been
lord.
given
I-
and all this.
The court, my lord, if it is allowed
They are
now.
not, we'll see on that day.
Please, my lord. This writ petition is filed either in ignorance of law or misconception. Otherwise, it is a misleading writ petition. That's what I want.
That will demonstrate, my lord,
My lord, the
how the.
very full court judgment, I would point out what is that.
My lord, if food vanishes, then I won't be able to have coffee, my lord.
No. We don't have the interest of the petitioner as such now.
My lord, in
Come
a
out with that
lighter
fact.
vein, I took the liberty, my lord.
What?
Number 35.
Appear for the complainant in the contempt petition. And, respondent in the writ appeal. Now, appellants in the writ appeal. Writ appeal is disposed of with a direction to hold election within 8 weeks. That order was passed on 2/1/2024.
Two 120.
There were two banks which had approached the court. There is a common order directing to hold election.
Which is the order under challenge? Page 59. 58, 59.
Would your lordships have contempt petition, my lord, for reference?
But who is arguing the writ appeal?
Nobody is arguing,
my lord. What we want to comply also, my lord. So we are.
I will only point out this, my lord.
Let us, yes.
Kindly see annexure A, page 19. Date of the order is 2/1/2024.
That is the order under contempt.
Yes, my lord, that is the order under contempt.
Yes.
In that, your lordship may also kindly look at page 24. There were two appellants. Davangere District Central Cooperative Bank also. Separate appeals.
Correct.
Kindly see the operative portion, my lord. Page 98. Sorry, it's page 68. 68. Page 68, bottom. In the above circumstances, with above observations, appeal are disposed of with following direction. The subject election shall be conducted preferably within an outer limit of 8 weeks. And for that, all stakeholders, including the government, shall take facilitative steps. As the interim order granted in the writ appeal was to expire, as per section 28A(5), administrator was also permitted to take over. This order is passed on 2/1/2024 in respect of two banks, two cooperative banks.
For Davangere Cooperative Bank, where the ruling party itself is in power, there was no difficulty for them to hold the election in compliance with the order of the division bench. As far as Mysore is concerned,
So original order was of learned single judge at page 98.
yes, my lord.
It is required to hold the election of Mysuru and Chamarajanagar District Central Cooperative Bank within a period of 120 days.
120 days was,
In the appeal, the order was upheld, but the timeline was extended.
timeline was extended, 8 weeks was granted.
8 weeks.
It was a common order in respect of 2 cooperative societies who were the appellants. For Davangere, they conduct the election. For Mysore, they don't conduct the election.
Damanagere or Chamarajanagar, same.
Chamarajanagar is the one for which they have not conducted. Page 24, which your lordship saw.
So you are showing page, where is the two?
Page 19.
Page 19 you are showing. So Mysuru and Jamnagar District Cooperative Bank.
This is
Other is-
1333 of 23.
Other is
page 24, Davangere District Central Cooperative Bank.
right. Correct. So what is the grievance now?
Even now, they have not taken steps for conducting the election. And now an application is filed saying, seeking extension of time on the ground that before the registrar, somebody has started a proceedings and registrar has granted an interim order. I can understand if someone was to say, there is an order of the Honorable Division Bench of the High Court, and they now say, registrar in a collateral proceedings has granted an interim order. Therefore, we want the time to be extended.
That is what they are saying. That is what your case.
Now that your lordship may kindly see the affidavit what we have filed.
Now the
We are going to conduct.
elections to this election to which bank
Chamarajanagar.
is held?
Yes, Mysore Chamarajanagar DCC Bank.
Mysuru Chamarajanagar is held.
Please.
To be held, my lord, to be held. Davangere has been held, my lord, page 24. Davangere has been held. What is to be conducted is that for Mysore and Chamarajanagar district. It is not our case, my lord, that because of the matter pending before the registrar, the election is not going to be held. We are given a schedule of dates as how the elections will be held in view of the interim order. Your lordship may kindly see, we are given the schedule, my lord, of dates. Along with the affidavit which is filed on 22nd August 2024. 22nd August 2024. Court officer.
Appeal is by whom? Appeal is by the Chamarajanagar Bank.
Yes, my lord.
Why? For what purpose?
No, that
Learned
has been,
single judge partly allowed the writ petition. We wanted the election which had already started to be continued from that stage. That was not granted by the learned single judge. Learned single judge directed fresh election within 120 days. Therefore, we had preferred an appeal for continuing the election which was already done. That was not granted in the writ appeal. Writ appeal said within 8 weeks you conduct the election. That was in January.
your lordship may kindly, it is not a case we are not refusing to, we want to hold the election. My lord. The time schedule has been given as to how to hold the election. My lord. Page 6 of the affidavit. We are going to hold the elections in terms of the cooperative society rules, my lord, after complying with all the procedure, my lord. Page 6 of the affidavit filed on 22nd August 2024. 22nd August 2024, my lord. In writ appeal, my lord, 1333 of 2023.
Your Lordship, can I skip page 5, para 12, my lords? Finally submitted that state amended by law 5A and 13(7) of the state deals with the constitution of the board of director and preparation of voters list for the election of the bank. Soon after the disposal of appeal, I started the election process by preparing the voter list, which needs 6 to 8 weeks. There is a possibility to conduct this election as per the rules on 3rd January 2025. Accordingly, I pray this honorable court permit me to conduct the election as per the time schedule submitted here. I submit there's no willful intent. Para 14, my lords. My lords, we are at page 7. Now, my lords, we are in the month of October, my lords. Serial number 6 has been completed. Page 7, serial number 6, my lords, will be completed. Then 7, 8 to 14, my lords, is the time schedule which we have given. In terms of the cooperative society rules, my lords, which requires this period which has been mentioned, my lords, is as per the provisions of the rules which has stipulated so much of time should be given. Can I permit it to show, my lords? As per the rules, they specifically say so much of time for each compliance has to be given, my lords. It's not our time schedule, my lords. It's as per the rules itself.
Of course, my lord, my learned friend, I would, before your lordships looking into that,
Just one
may
submission.
bring to your lordship's notice, page 68.
One submission.
This contention was advanced in the writ appeal. Then the court said, we permit marginal relaxation for the timelines prescribed in the extant rules and also period fixed by the learned single judge in his order dated so and so. Page 68. Page 68, division bench. Second sentence. Now that the CEA and jurisdictional EOs are taking steps on a war footing, the process of election should be accomplished in true letter and spirit of the impugned judgment. At the same time, we permit the marginal relaxation for the timelines prescribed in the extant rules and also the period fixed by the learned single judge in his order dated so and so, keeping in view the apparent difficulties of authorities may counter in exercise. Since this concession is being made in peculiar circumstance of the case, no one need to have any apprehension that this view would be having any precedential value. Therefore, fixed 8 weeks.
In fact, when the matter was
granting relaxation of that rules.
In fact, my lord, it was
In spite of that, they want to come up with the.
When the judgment was pronounced, my lord, we requested the court saying that it will not be possible to do it. The honorable court was orally pleased to observe, my lord. If you require time, kindly mention it. We will consider it at appropriate stage, my lord. In fact, this is undisputed fact, my lord. We had mentioned to the when the judgment was pronounced itself, my lord, it will be difficult to hold the election in this period, my lord.
This difficulty of timeline did not arise for Davangere DCC Bank.
Because there was no prohibition or there was no difficulty, my lord. In fact, in view of stay of rule 5A, my lord, we had to redo the voters list and conduct the election. Therefore, my lord, it is not that there's in contempt of willful or intentional disobedience. We are complying with, my lord. All we are saying is we'll adhere to this time schedule and we'll conduct the election. Well, it is not the case we are trying to violate. This is the time schedule. We will not violate this, my lord. Your lordship may have it monitor this, my lord. We'll see that it is election is conducted strictly in terms of this time schedule, not in a date delay, my lord. Strictly in terms of this time schedule, my lord. In fact, it has already started. Till serial number 6 is almost being completed, my lord. Then what is remaining is date of election also we have mentioned, my lords. Third January. Copy. Give one more copy, no? Sorry.
The time now they are seeking is also more than 8 weeks.
We are
The time which now they are proposing, even taking the date today, it's more than 8 weeks.
My lord, what has happened is rule 5A has ought to be stayed. We have to redo the whole thing, my lord. It is that's the whole reason, my lord. The voters list has totally changed, my lord. In fact, the election, we have informed the election authority also about the same.
This appeal is by who appears in appeal?
Well, appeal has been,
But who appeal? You are
appearing for the state in that, my lords.
no.
District,
Kamaraj Nagar and my, who appeal?
that is my learned friends were appearing for the,
Appellant, I was.
Appeal is yours.
yeah,
Contempt is also yours.
yes. In fact, it is a case where we are saying that we'll comply, my lords. Your Lordship, may I have it, we'll keep monitoring after each schedule, my lords. We'll see that it is complied with, my lords. There's no further delay will be done strictly in terms of this, my lords. In fact, if your Lordship says we'll file additional affidavit, my lord, saying that we will not seek any further time also, my lords. And the matter can be kept pending also before your Lordship. If they have any apprehension that we are going to postpone the elections.
We have crossed the stage of apprehension. We have now accepted that you will not hold election.
That's why I said, my lords,
Now, what is the statutory period? Calendar?
as per the statutory period only I mentioned, your Lordship may now see, my lord, page 7 of my affidavit.
It extends to how many weeks?
Yeah, my lords, in fact, my lords, for as per rule 13D, my lords, it is 25 days, my lords.
25 days.
Per each schedule. So we have gone strictly, my lords. And otherwise, my lords, again, they'll challenge.
No, your timetable is extending about 25 days.
Because Lok Sabha elections had come in between, my lords. Because of that also, little it got delayed, my lords.
No, where is
Parliament,
where is the timetable is?
page 7 of the affidavit, my lords, starts at page 6 of the affidavit dated 22nd August 2024. IA, please. Can I give I'll give my copy.
No, I just.
Page number 6, page number 8.
Page number?
Starts at 6, my lords. Of the affidavit dated 24th August 2024. 22/8/2024.
Very good.
Para 14, my lords. Now we are, my lords, at page 7, yet we are at serial number 6, my lords. Your Lordship, can I read permitted route serial number 6 at page 7, my lords?
Only we are trying to verify whether on the date of order of the division bench.
To 2nd January 2024.
Even leaving,
Process had not started.
Not started.
even leaving
Your Lordship,
the
may kindly see.
direction, my lord,
Page,
if they
page-
were sincere,
Page 7, my lords, of my,
2-1 is the order.
page 7.
195 days is the last limit under the rules.
Parliament,
Even then, it should have been over by August.
my lord, Parliament election came because of code of conduct was there for 3 months. When the order was passed on 2nd January, code of conduct was not there. These are practical difficulties which has arisen.
With due respect to my learned friend,
which-
he may peruse that notification. Parliament election, when elections were postponed, it is specifically stated, wherever there is court order, this postponement will not apply. That notification itself specifically provides.
Your Lordship, page 7 may be kindly seen, my lords, for the affidavit at serial number 6.
This order dated 2nd January was served to you on which date?
2nd January, sir.
You appeared.
We had appeared on 2nd. Well, we are not standing on, Malot. Ultimately, Malot is not a willful and intentional, Malot. What we are saying is, Malot, Parliament election had come in between. Subsequently, Malot, there was a stay of the Rule 5A, Malot, which of the bylaws, Malot. We had to redo the voters list. We will strictly adhere to the affidavit which was filed before your lordship. We will strictly comply with holding of elections in terms of this affidavit, Malot. Your lordship may kindly have it, monitor it, Manoj, not in a day's delay as mentioned in our affidavit, Manoj. In fact, Manoj,
We'll take up on. Let it be for orders. Let it be, we'll consider. For orders on 20, on 28th of.
well, only thing, my humble request to Manoj is, your lordship kindly take page 7 of the affidavit, Manoj, which I filed. Okay, I'll make my submission on 28th, Manoj.
No, 28th for orders.
Order. Only your lordship may kindly.
You want to make submission, then for submission.
I'll make my submissions on 28th.
28th.
Manoj. Just.
Then let it be little earlier because time is running.
Manoj, the reason is this, Manoj. We'll stick, my only submission is, Manoj. The lordship may have it on 28th, Manoj. For submission itself, if.
Or
I'll.
28.
Please. Grateful to.
Non-filing in contempt matters. Number 36.
Lord, I appear for the complainant in this case.
Yeah. Number 36.
My lord, I appear for the complainant in Lord, this case.
I will get the instructions, my lord, since my client is aged about 98 years. Copy is served on the counsel who is representing the accused in the RFA, my lord, pending RFA. 2 weeks, my lord.
12th November.
Great.
Number 37, Mr. KV Narasimhan.
Appearing for the accused, my lord.
My lord, they have rejected my representation. My lord, maybe liberty may be reserved
The
to challenge
direction
the
of learned single judge was to decide the representation. The representation decided, although it is rejected. In the above view, the contempt proceeding does not survive if the decision is taken. Full stop. A grievance in respect of the merits of the decision cannot be considered in the contempt proceedings. Liberty is reserved for the petitioner to challenge the decision of the authority, if advised. comment in an independent proceedings in accordance with law. This court does not express any opinion on the merits of such recourse or merits of the controversy.
Much obliged.
Number 38,
Contempt petition is disposed of accordingly.
That's
38, Sangamesh RB.
my lords, as a last chance, I pray for some time, my lords.
5th of November.
Obliged.
Number 39.
That's,
The complaining.
I pray for 2 weeks' time, my lords, to secure instructions in this matter. I pray for 2 weeks' time, my lords, to secure instructions.
November. 12th November.
Number 40. To Vasant Kumar HD.
For responding. Praise 2 weeks' time, my lords, to secure instructions and
You are for complainant.
respondent.
Oh, no. All right. 11th. Representation. 7th of November.
Grateful.
Number 41. GR Mohan.
Appeal for the petitioner. This matter pertain to rejuvenation of Rishabhavati River Valley, wherein this, your lordship has passed an order on 29th July 2024. So they are required to have a meeting. July, your lordship.
My lord, I apologize, my lord. I had to submit a report as per the orders passed by my lord on 29th July. My lord, could I pray for 2 weeks' time, my lord? Very old. My lord, I just got the file, my lord, so I couldn't. I won't move for an adjournment on the next.
One
Additional government.
submission, lordship.
Neil
On
Parekh
29th,
time
I
to
filed a
file
memo,
report,
your lordship.
which was required to be filed in light of earlier order dated 29/7/24.
And-
Send over to 13th. November.
One submission, lordship. On 29th July, I filed a memo wherein in the area which has been earmarked and a survey has been conducted in RR Nagar. Now the school building has been constructed, your lordship. Huge building, produce the photograph, your lordship. Kindly.
Yeah.
The survey sketch is also given by the survey report. Now, if some water, now heavy rains are daily happening, school children will be get affected because of just without even leaving any buffer zone, the school has been kindly look at it for a moment. The memo filed by me on 29th August. Because it is for the BBMP to give response what steps they are going to, because it is an unauthorized school, no plan, nothing. And the survey as per the NERI report and the government, it is clearly encroachment. It is. And children's lives are in danger if it is overflows.
You are
The
anticipating.
photograph also, what is the map also?
You are anticipating heavy rains.
Yes, sir.
We'll consider that.
In fact, yes, because yesterday also, today also report has come. They did the Taram water drain want to beautify it from Kalaspalam KR market, which is a Rishi, Rishi, what is that's called? The valley they wanted to make it as. In that also now the garbage have been thrown and it is not maintained at all. 172 crore has been spent for that project. Last year it has been inaugurated. So like this, it is happening here. So unless they coordinate with the revenue for DC and as your lordship passed an order, so it can. Because again now heavy rain, my response submission.
Heavy rain.
Yesterday heavy rain, your lordship, it's all flooded. Several areas have been flooded, and this valley runs to that area only.
13th November.
Yes,
Number 42.
please.
This matter, I filed an application this morning, filed an application for impleading this morning. Registry may be directed to put up the file, filed an application today. I shared the copy on the other side also.
My lords may kindly see the order
Lord,
dated
if he
28/7.
has filed impleading, my lord, I received the copy just now, my lord. I'll have to file my objection. Apart from that, my lord, on 29/7, my lord, there is a direction to the government to file a statement. And they have not filed it. Last date of hearing, my lord, on 29/7. Kindly see the order, my lord.
This layout in the forest.
Yes, my lord. There's a layout in the
according to
forest
the-
land, my lord, and there is a report. This honorable court directed is spot inspection, joint spot inspection. Report was filed. To the effect that, my lord, it's a forest land. And even the government has filed a statement of objection, and forest department also filed a statement of objection, stating
There is
that.
an order of Supreme Court to proceed with it.
My lord, may I request
Yes,
your
ma'am.
lordship
That's
kindly
why-
see, my lord, the order dated 28/7, my lord.
That's why
28/7.
government is supposed to file the statement on a particular aspect, my lord, your lordship directed.
29/7.
29/7. Yes, madam.
28/7/2021, my lord. When this matter came up before this court, my lord,
Kindly see the last date of,
we brought to
last
the
date
notice,
order, my lord.
we brought to the notice of this honorable court that
But
there
if
is a
the government is not filing, my lord, I will file my synopsis and matter may be taken up for final disposal. 29/7, my lord.
Then
In pursuance of this, my lord, we produced a notification of 1961, wherein these lands, my lord, were deleted, my lord, after following the procedure prescribed under the Act. It is no longer a forest land. My lord, this honorable court wanted to, my lord, the opinion of the government to see whether this notification was genuine. And they have been, whether it is genuine or fabricated. It's a gazette notification. And the government is taking time, my lord, to find out whether this notification is genuine or not. We have also produced, my lord, the
But,
proceedings of the
my lord,
proceedings, my lord, of the government, my lord.
if the government is
The
filing the
survey-
statement,
Survey, they have done the survey, they have verified the document, and thereafter, my lord, a notification is issued in 1961.
it is for the.
Now thereafter, my lord, the town planning authorities, my lord, have declared it as a yellow zone. My lord, prescribed yellow zone. My lord, prescribing, my lord, the usage of the land for, my lord, schools and colleges. And permissions have been given, my lord, to several colleges and schools, my lord, to construct, my lord, the education institution. Now at this stage, my lord,
who are you?
my lord, my lord, I am the owner of the land, my lord, which my learned friend is saying, my lord, it is a forest land.
My lord, let the
My lord,
government.
first earlier round, my lord, the writ petition, my lord, it was dismissed, my lord, after making a survey. And the forest department and the government, my lord, after the survey, submit a report to this honorable court saying, my lord, there is no encroachment of any forest land.
My lord, if the government is filing statement.
Thereafter, my lord, the second writ petition is filed. Producing, my lord, the old notification,
Now your notification produced at which page?
my lord, in my objection statement, my
Lord,
lord, notification is produced. Annexure R4, my lord, at page 28, my lord.
That is under section 6,
Respond-
my lord. It is the,
Respondent,
by the survey settlement officer.
Of objections of respondent. 27/8/21. 27/8/21. 8/21.
annexure R4, my lord.
ವಿನೀತ್ ನಮ್ಗೆ ಏನಕ್ಕೆ ಬಂದಿದ್ದು ತೋರ್ಸ್ ನಂಗೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್.
This is a copy of gazette.
It
This
is a
is,
co-
this
gazette
is, my
copy,
lord,
my
there
lord.
is no dispute about this, my lord.
My
What
lord,
they are
when they
saying
file
is
a statement,
exclusion.
rejoinder, my lord, saying that, my lord, it is concocted, fabricated, Therefore, my lord, this
But he
honorable
is,
court wanted to know, my
lord,
lord, from the government,
He's
whether it is genuine document or not.
making statement, my lord, is not correct. My lord, I will maybe submitted, I will submit, my lord, if the government is
Will be
filing.
able to get the copy of the original gazette.
No, they are supposed to file a statement. That's what last directed them, last occasion. They state that they will file a statement. That statement is almost, my lord, they have to file, my lord. If they are filing it, my lord, I will argue them on merit, my lord. They have to
Yes.
take a stand.
The original Mysore Gazette of,
This is under section 6. There is no exclusion.
it must be available.
Lord, I'll get it, my lord.
That's what, my lord, they are supposed to file it. My lord.
I'm sorry, my lord.
Any date, my lord, I will file my synopsis also. I am ready for it.
Any of the order of the Honorable Supreme Court dated 12/2/24 passed in special leave petition in civil bracket over diary number 4685/24. The present petition is directed to be listed for hearing on 24th at 2:30. Please,
Obliged, my lord.
24th of October.
Lord, we have produced, my lord, some additional document also. my lord.
Whatever you want to,
I'll give
please,
it to.
you're welcome to produce.
Let AG do what he wants.
All are welcome to produce everything. But we'll proceed with the, that's all.
25th year. Yeah, we have it. Lord, may I request 25th, ma'am?
25th.
Please.
20.
Lord, one submission, my lord. Lord.
Yes.
Serial number 33, my lord. Serial number 33, my lord. I was not there, my lord, when case was called. I request a short date, my lord.
It must have been urgent.
It passed over, my lord.
You
It's
want
passed
date?
over, my lord. I request short accommodation, my lord.
Date, all right. 13th November.
Obliged.
My lord, that's the
58, my lord.
43,
Please,
my lord. In
oblige, my lord.
33, I was the respondent.
Same matter,
Yes, your lordship, which. what-
then earlier, 7th November.
Great.
Serial number 43, my lord.
Serial number
Two
58.
2 weeks time, serial number 43.
Mention it 2:30 after this.
Serial number 52, my lords.
Girish sir. Girish sir. Girish sir. Girish sir. Court officer. Court officer.
ಹೇಳಿ ಕೇಳಿಸ್ತದೆ ಹೇಳಿ ಸರ್.
ಯಾವ ಡೇಟ್ ಕೊಡ್ತೀರಾ ಸರ್?
13th November ಸರ್.
ಹಾ ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
13th ಅಲ್ಲ 7th November.
ಹಾ ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
7th November.
ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
Court officer, sir. Court officer, sir. Lordship may kindly serial number 51. Certain serial number 51. Grant 2 week time because I apply for some documents. Therefore, it is a new case.
5th of November,
6th.
6th November.
6th.
Much of I mentioned, my lord, serial number 55. Government had to file a report. I believe, my lord, it is not ready.
Please, my lord, in this
So if
we
your
need a
lordship
short
serial number-
accommodation.
Serial number?
55, my lord, 55.
That is a contempt, madam.
My lord, there are two. One is a writ appeal and my lord, another is a contempt, my lord.
Yes. Writ petition and contempt.
Yes, my lord, writ petition and the contempt. In that writ petition, my lord, it is the writ petition, the government had to file, my lord, a report. There's some dispute between so my lord, 2 weeks time, I think,
Lord,
if your lord
just for a
call it
week's
after
time.
2 weeks.
The week's time, my lord, a date may be,
Whatever, I have no problem.
In the writ petition.
a date may be given, my lord, in this matter.
So when do you want?
Whenever, my lord, subject to your lordship. Depends
My
on
lord,
the
2
government.
weeks, my lord.
All- all right.
7th November.
Please,
Obliged.
grateful.
58, my lord.
58.
2 weeks, my lord, sir.
What is it about? Other side is no objection.
Appear for the complainant, lords, they have to pay me the compensation, lords. They have made the road, it's a national highway, lords. It is against the national highways. There is a
I filed
direction.
the affidavit, my lords, translation copy
There
has
is a
to be
direction
filed, my
to,
lords.
lords, pay me the compensation. It has been 1 year. They have not paid the compensation. They have already utilized the property, my lords.
8th November.
Please.
Obliged.
So passover matters, seal number 2. To Naveen Chandrayan. Seal number 2, to Naveen Chandrayan.
None was present. When the petition was called out in the first session as well as post-lunch session, it could have been dismissed for want of prosecution or in the larger interest of justice. Stand over to. Second December.
Seal number 3,
And for the
Girish
complainant, your
Krishna.
lordship. And for the complainant, your lordship.
Lords, compliance affidavit has been filed.
We have not received the copy.
To serve the copy as no point in telling the court it is complied with. You serve the copy. What is the direction?
Lords, this is to consider the representation, my lords. The D group workers.
Give copy.
Your lordship, time may be given. Take instruction from the client, your lordship. You've just received the copy.
Tomorrow,
2 to 3 days time may be given.
22nd at 2:30.
Number 43. That's why Shivali.
The first matter not, I engaged, not in the first matter, not I engaged the service of senior counsel, Sri Panindra, who has argued this matter at length in previous occasion. But today, not,
What do you want?
not, I've engaged the service of senior counsel in this matter, but I could not. My matter may be heard, mine is a 2022 matter, and wherein I am a query lease holder, whereas the city first petitioner is query lease applicant manner. That makes totally a different situations altogether. And I will be concluding my arguments very briefly within 10-15 minutes, because on the other, last occasion matter was heard in part matter.
I only will sum up and distinguish the legal position only based on documents, my lords.
All are connected, Mister. All are connected.
All are connected, but identical issue is involved. In my case, not my application is rejected. In their case, license was granted, it has been cancelled subsequently. But issue involved is about.
When your counsel will be available?
Not because of my inconvenience, I could not inform and get it. I will. Let you.
Otherwise, my request.
Day after tomorrow, not.
24th. 24th.
Much. Number 44.
But to appear on behalf of the Amai customer. My lords, pursuant to the last order, the committee was to furnish its report, my lord.
Yes.
My lords, pursuant to lordship's last order, the committee was to furnish a report.
My
I
lord,
believe the
yes,
report is
at
not-
serial number 6, my lord had directed the Dam Safety Committee,
Yes.
my lord, to take a decision and then to place the same on record. My lord, I have not received any instructions. If my lord could grant me
They
some
have
time.
taken a decision saying that they have no jurisdiction. It is the state government which has to take a decision, Merit.
About?
Your lordship directed the Dam Safety Committee whether the conduct of crushing operation and quarrying operations will any manner affect the safety of KRS Dam. Milord, I understand, Milord, we have not been served. So we have been informed, Milord, that the Dam Safety Committee, which is your lordship directed, taken the view that they have no jurisdiction to decide whether the conduct of quarrying operation will affect the safety of the dam. It has to be
For what?
decided by the state government.
Your committee is functioning for what? If not for dam safety. Name
Like-
is dam safety.
Milord, most of the writ petitions and applications, Milord, your lordship dispose of directing the committee to decide whether the conduct of quarrying operation in a range of 20 kilometers affect the safety of KRS Dam.
Correct. So it's
So
not-
your lordship's direction, Milord, now they have issued endorsement to them, Milord, but I have not been served any. This thing, some of them have been served, saying that the Dam Safety Committee under the Dam Safety Act has no jurisdiction to decide.
Where is the terms of reference of committee?
Yes.
There must be terms of reference.
No, your lordship directed, Milord, in this.
Where is the terms of reference for that committee? Which are the dispute the committee can go into?
Milord, they have
For
produced.
every
the-
committee, there is a terms of reference.
Yes.
So where is that? You tell us. It was there last time. We had seen that.
My lord, it's
For
part
passing
of
the
the
order.
objections filed by the government. It's part of the objections filed by the government.
The committee is constituted by which order?
Committee is constituted under the Dam Safety Act, Milord.
By which order?
That they have produced, the state government has produced those orders to your lordships.
The page?
Yes. Annexure R1, Milord.
Of the
Translated copy, your lordship get page
R1 of the petition,
of the statement of objection.
statement of.
Please.
Where is the statement of objection?
My lord,
Milord,
it's dated 5/12/2023.
Annexure R1, my lord, Kannada starts at the translated copy of Lordship case 25. my lord.
File a report, then we'll.
I will.
There was also, my lord, they undertook to your lordship, they will conduct scientific study. Till now, no scientific study is conducted. That is the reason your lordship listed today, so that they will conduct a scientific study and submit the report to this honorable court.
When?
My lord, 2 weeks, my lord.
Fourteenth November.
Obligement. No, something is coming. July 9.
This is number 45, Amrutesh NP.
For the second respondent in this.
Appearing for the respondent number 2 in this matter, Your Lordship.
R3, Keshavam Datar. Our name is showing false list. May be deleted. Keshavam Datar, name may be deleted, my lord, shown in the cause list for R3.
R3. What is to be done?
Keshavam Datar. Keshavam Datar, name may be deleted.
Name to be deleted.
My lord, fifth respondent,
The vocal.
the fifth respondent is the state, my lord. I don't think Mr. Datar appears. Assistant Commissioner of Police, the state appears.
No, why?
R3 is Commissioner BBMP himself. R3 is Commissioner BBMP, my lord. I've also filed my wakalat for R2, my lord.
Nobody's name to be deleted. You are for R3?
My lord,
No, my lord. No, my lord, our name is showing in cause list.
Let it be. Commissioner BBMP, NR square by NR.
Lord,
We have no instruction.
Lord, I'm sorry, my lord. May I make my request? R3, 4, my lord, I'll be appearing. Mr. BL Sanjeev will be appearing.
Say you must be deleted, so we're deleting you.
Yes, my lord. His name is
What is your good name?
PS Srinivas for BL Sanjeev.
P.S. Sanjeev.
Yes.
Is deleted from here.
Well, I have filed wakalat for 3 and 4, my lord. Mr. Datar also.
Telling why you to delay is appearing.
No. Mr. Datar has also, my lord, has filed was direct to take
It's
notice.
between you and the Das and Sanjeev and we are not concerned. We are happy if 2 Wakilatnama comes. Say what is to be done, not these miscellaneous things. It is for you to decide who
Lord,
to file Wakalatnama.
my request, my lord.
Not for us.
I may be permitted to file my objections in this matter, my lord.
This is PI.
Yes, my
Yes.
lord.
Yes, ma'am.
LED display,
The display boards which have been put up on,
the brightness emitted by the lights, my lord, causes a lot of sensitivity. My lord, the police commissioner has written to the commissioner BBMP, but no action has been taken.
We'll keep with that. Where is that Lexis matter is coming?
my lord, I'll just get the date, my lord, on the same day.
Court of, yes, to be listed with that. Find out the number, Lexis PA.
Much obliged.
Number 46, Mr. Tyagarajas. Yes.
For the petition.
My lord, my statement is ready, my lord. I'll file it in the office. My lord may call this on Monday, my lord.
Notice has been ordered, my lordship. The statement of objections, my lordship, they have not served
My
upon.
lord, my statement is ready. My lord may have this on Monday, my lord. I'll file it in the office.
Who are you?
I am for the petition, my lord. We are all
Who are you?
residents of the village and agriculturist in the catchment area of the reservoir. We have filed this writ petition, my lordship. It is a small reservoir which is meant for drinking purpose and for cattle. In the year 2021, my lordship, that small reservoir was overflown. There is no inflow river to the water facility for this reservoir. It's a small reservoir, totally purely depending upon the monsoon, my lordship. There is no need to release the water from the reservoir to any other purposes, my lordship, except the drinking purpose. The respondent, the government has already declared that the reservoir water is reserved for only for the drinking purpose for the Jal Jeevan mission. But the respondent, without considering all these aspects, my lordship, even we have made several representations, has released the water from the reservoir for the 45 days, my lordship. Therefore, with the agriculturist as well as the villagers have made representation to the respondents with the request not to release the water from the reservoir, and also without cleaning the canals, my lordship, they have released the water which was simply wasted on the road. I have produced the photographs, my lordship. No purpose was served, my lordship, by releasing the water from the reservoir.
My lord, the writ petition will not survive, my lord. My lord may have this on. The writ petition will not survive. My statement is ready. I'll file it in the office. If my lord could have it on Monday, my lord, it will not survive.
Yes. Heard learned advocate.
Because my lordship, further my lordship, now, even though there is a monsoon started, I do not know whether, what is the status of the water level, my lordship. That's what, it may be have it on next week, my lordship, I will get with the my lordship with the.
Heard learned advocate, Mr. So and so for petition. And learned additional government advocate, Srimati Nilofer Akhtar. Or the respondent. The present petition is filed. Styling it as public interest petition. Petitioners are the villagers. What they have right paragraph. Is for issuance of writ of mandamus, requiring the respondent authorities to immediately stop the water release, public water outflow from the Bora Naka Naive, PORANAKNIVE reservoir at Chikanya, CHIKKANAYA, Kahanali, KNA, Taluka, Tumkur district. It is next spread to require the respondent authorities to consider and dispose of the representation dated 25/1/20 made by the petitioner, as well as the subsequent representation dated 1/2/24. The grievance paragraph, as essentially raised, is about the release of the water from the said reservoir. It is stated that on 18/11/23, the respondent number 4 the Assistant Commissioner, TIP 2 subdivision, TIP 2, resolved to release water from Borana Kanavi reservoir for 45 days. It is the case that the decision to release the water was not justified in as much as the water is not available in sufficient quantity for agricultural activities, and that the water stored in the reservoir is in less quantity. It is stated that the water is necessary to be reserved for drinking purpose, and that due to absence of regular monsoon and the rainfall, the reservoir had no inflow of water. It was then stated that 50 surrounding villages have been dependent upon the reservoir water for drinking purpose. It was stated, it was the case that respondent number 4, by allowing the outflow of water from the reservoir by opening the gate of the reservoir, has acted against the interest of agriculture and the need of the water, and has disregarded the need to Reserve the water for drinking purpose. It was stated, it was also stated that cleaning of work of water canal was not undertaken before release. It is to be noted, paragraph, that the decision complained of by respondent 4, which was of releasing of the water from the reservoir for 45 days, was dated 18/11/23. When this petition comes up for consideration, the petition was filed in the year 2024. This petition was filed on 27/2/24. On the date of filing itself, the period of 45 days had passed by. Paragraph. In addition to the above aspect, the petitioners have already made their representations mentioned above, copies of which are produced along with the memorandum of the petition. They are pending and yet to be considered. Full stop. The decision which may be arrived at by the competent authority on the representation of petitioner may guide the future exigencies. Paragraph. The weighty reason for not entertaining the present public interest petition. For my part, the aforesaid considerations is that release of water from the dam or reservoir, the quantity of such release, whether to be released, whether the water is to be released or not, and for what period, are all the decisions in the technical realm. Full stop. They are also the policy decisions based on technical considerations and the actual needs to be assessed by the authorities in that regard. Full stop. The court has no role in this sphere. Full stop. The court cannot monitor, oversee, or guide the aspect of release of water from dam or reservoir. Full stop. Public interest petition on this score, SURE, would not be entertained. Paragraph. The petition is dismissed.
The Subramania R.
Lord, I appear for the petitioner.
Yes.
Lord, this is a petition, my lord, in public interest. Lord, for maintenance of the park, my lord, reserved, the area reserved for the park by the KIDB in Hassan city, my lord. As Annexure A is the, my lord, Annexure A is the sketch I have produced, that is the layout plan in which the area 221P was reserved as a park. Then, my lord, several persons filed application for allotment and the KIDB rejected such requests. Annexure C, my lord, page 44 is one, and my lord, is one of the rejection letter. It didn't grant it for private purposes. Then, my lord, very strangely, this land was allotted in favor of the fifth respondent. Then, my lord, in 2013 itself, my lord, Annexure E, page 58, the KIDB temporarily, my lord, withheld the allotment. Page 58, my lord. Lord, the last at page 60, the order portion. In the background of all the above aspects, in exercise of power vested by so and so, the The board withdraws the allotment of Hasan Growth Center Industrial Area Site number 221, measuring so and so. Made in favor of Pushpagiri warehouse until the further orders. My lord, thereafter, my lord, the residents, my lord, as per Annexure F and my lord, we gave representations to develop it as a park. In fact, my lord, we planted, my lord, on the World Environmental Day, my lord, we planted hundreds of trees also. Later, my lord, the fifth respondent illegally removed the, my lord, the plants. Therefore, my lord, we are seeking for the development of this park area and without diverting it into a good park, my lord. My lord, in the meanwhile, my lord, as per Annexure H,
Diverting for?
my lord, it has been granted, my lord, for the construction of a warehouse.
Construction of warehouse.
Please, my lord. My lord, now the fifth respondent, my lord, he approached this on the learned single judge, my lord, by filing a writ petition. And my lord, as per Annexure H, the cancellation orders were set aside and directed the KIDB to reconsider the matter. Page 70, it starts, my lord, Annexure H. The KIDB, my lord, did not, my lord, pass any orders regarding cancellation. They went on, my lord, postponing it, the development of the park. Now, my lord, the KIDB has filed a, my lord, writ appeal, my lord, 1005 of 2024. My lord, that is coming upon, my lord, 21/10/2024, my lord, on the very same issue.
I appeal for respondent number 5 in this case, my lord. We have not received the copy of the petition, my lord.
All of a sudden you remember. All of a sudden you remember that copy is not received.
Lord, I will furnish another set of copy.
Lord, your lordship may tag this matter along with writ appeal 1005 of 24, which is coming on 21st of October.
You also don't have copy.
No, I have the papers, my lord. My lord, the KDB has filed an writ appeal, which is coming on 21st of October. This matter can be taken along with that matter.
Oh no, why?
My lord?
Why?
My lord, the land was allotted to respondent number 5. Then for non-implementation, it was cancelled. They called in question the order of cancellation. That was set aside and remanded back to KDB, my lord. On that order, we have filed an writ appeal. The subject land is similar to the writ appeal and PIL. The subject land is similar.
Similar or same?
Same. Not
same,
similar.
very
my
same
apologies.
issue,
Same,
my
my
lord. Same issue.
My lord, writ appeal number 1005 of 24.
Writ appeal?
Writ appeal, my lord.
Of 23.
24.
What is that writ appeal? What is the challenge of that writ appeal?
My lord, the learned single judge, my lord, set aside the earlier communications.
What
That,
is
my
the
lord,
challenge
which temporarily, my lord,
What is the
temporarily
challenge in that
cancelled.
writ appeal?
My lord,
My lord, the order of the
petition
learned
order
single.
is challenged, my lord. Writ petition ordering at annexure page number, annexure H page number 10. That is challenged in writ appeal.
Page number 70.
70, my lord.
70.
70. Annexure H.
So Messrs. Pushpa Giri is number 8 here.
Respondent number 5, my lord,
5, sorry, 5.
please.
Who has filed appeal? Who has filed writ appeal?
Writ appeal is filed by the KADB, my lord.
Lord, the order of the learned single judge is directing the board to consider the case of the petitioner therein, my lord. In fact, my lord, they have to, initially they have cancelled it. Thereafter, my lord, they have kept on postponing the development of the park, my lord. The park area cannot be diverted, my lord, that the KIDB has to ensure, my lord.
Hard learned advocate Mr. So and so, who appeared and argued the petition online from a learned additional government advocate, Srimati Nilofer Akbar, for respondent state and its authorities. Learned advocate Mr.
BB Patil for respondent number 2 to 4, my lord.
2 to 4 and learned advocate Miss.
5, my lord, Shiv-Kumar, my lord.
So and so. Give your appearance. Number 5. The petitioner's paragraph, who are the residents of the Nagatawali village, have brought this petition as public interest litigation. Their grievance is that the authorities have not been developing plot number 221 in survey number 54 of Hassan Growth Center Industrial Area as a park, which was so contemplated in the layout plan. It is stated that respondent Karnataka Industrial Areas Development Board published modified layout plan dated 20th/1/2000 for Hassan Growth Center Industrial Area in the aforesaid survey number, which admeasures 1686.38 acres, and that in the site plans, plot number 221 was recorded as government land since many years. Because it is the grievance that despite the park designation, despite the designation as a park, even to the said plot number, the efforts are made by certain individuals to obtain the said plot for commercial purpose. Based on the aforesaid basic premise, what is prayed by the petitioners is to direct respondent authorities to develop park in the said plot number 221 in survey number 54 of the Hassan Growth Center Industrial Area. Paragraph. It is the case inter-alia. It is the further case inter-alia that private respondent number 5 obtained letter of allotment and got possession of the plot. It is the say that, it is the say of the petitioner that subsequently the allotment letter was revoked. It appears that writ petition number 5657 of, it appears and not in dispute that writ petition number 5657 of 2017, wherein the present respondent 5, as Messrs. Pushpagiri Warehouse was the petitioner, ended up in its favor as the petition was allowed, and the allotment of the plot in favor of the said petitioner was upheld. Copy of the judgment and order of learned single judge in the said petition. Copy of judgment and order of this court in the said petition figures on record. It was stated that appeal has been filed by the, who has filed appeal?
KIDB has filed, KIADB.
Karnataka Industrial Areas Development Board has filed appeal against the said order. Be as it may. The totality of text paragraph and having regard to the subject matter grievance, the court is not inclined to entertain the petition as public interest petition. While this petition is dismissed, the petitioner is not precluded from making a representation to the competent authority to voice his grievance. If such representation is made, the same may be considered strictly in accordance with law. This court has not expressed any opinion on merits, nor has gone into the merits of the controversy. Dismissed as above.
Obliged.
Number 48. Testify Shivali.
This petition, Lord, has become infructuous.
Yes.
This petition has become infructuous.
Honorable Advocate Mr. Shivayogi Yallappa Gowda stated that the present petition has become infructuous, accordingly dismissed as infructuous. His fellow learned dismissed as infructuous. Before that, learned additional government advocate Srimati Nilofer Akbar confirms that the petitioner no more survives.
Number 49.
In serial number 49, I appear for the respondent number 2, my lord. Senior counsel is not available. I pray for a week's time, my lord. I have engaged the senior counsel KG Raghavan for this.
For admission, my lord, it's an appeal where, my lord, I was the writ petitioner. My writ petition is allowed. I have succeeded before the learned single judge. But, my lord, I am only aggrieved by the last part of the direction which my lords would find at page 34, by which, my lord, the Deputy Labour Commissioner, my lord, is directed to open a fresh reference between two third parties as an industrial dispute and decide. So court confers jurisdiction, my lord, on Deputy Labour Commissioner to decide something which is beyond the ID Act. Original dispute, my lord, was that there was a original reference which resulted in a settlement. That settlement with my lord, the union, which had, my lord, 410 employees, that settlement has been my lord, completed, put into action. They wanted to raise a second reference, my lord. I challenged it in a writ petition by saying that once there is a settlement, the question of a second reference did not arise. That, my lord, I have succeeded, and the writ petition is allowed.
So where is the prayer in the writ petition?
Prayer, my lord,
48.
page 58, my lord. No, one second.
Page 48.
The petition is allowed.
Petition is allowed. But this subsequent direction, my lord, to say under 226, I
Page
exercise
50,
the.
50,
Pardon.
page,
Page 48 is the prayer.
no, not,
The impugned order, my lord, at page 34 and 35, the last two paragraphs.
no, prayer in the writ petition.
Prayer in the writ petition is at page 48.
40,
Call for records in ID number 134.
40,
Quash the reference,
yes.
annexure A. This, my lord, is allowed. Because this was a second reference after settlement. At page 33, bottom of the page, my lord, court allows the writ petition. This subsequent direction, my lord, is something which is extraordinary and conferring jurisdiction, my lord, on the Deputy Labour Commissioner and directing that he will enter a reference in respect of what is not a dispute as defined under the Act.
So this was done at whose request?
Lord, at the behest of a third party,
Godrej.
yes, my lord,
Godrej.
who came with an application to implead, that impleading application is rejected. But, my lord, if there is a,
Heard learned senior advocate Mr. So-and-so, assisted by learned advocate Miss so-and-so for the appellant.
I represent the respondent number 1 state, my lord.
Learned,
I got a
learned
submission to
additional
me.
government advocate Mr.
Government advocate K.S. Harish, my lord.
K.
Yes, Harish. Government
H.
advocate.
Harish.
K.S. Harish,
K.
government
S.
advocate.
Harish.
But I got a
And
submission.
learned advocate Mr. Pradeep Kumar R.H. For? You are muted yourself. You have muted yourself, Mr. Harish, Mr. Pradeep Kumar.
But I
You
appear
are
for
for-
the respondent number 2, respondent number 2, my lord.
Mr. Pradeep Kumar R.H. for respondent 2, who appeared and made submissions online. The present appeal arises out of judgment and order dated 21st November 2023, whereby the learned single judge has allowed the petition and proceeded to issue further direction as contained in the order. The prayer, the writ petition filed by the appellant petitioner was as under. One and two. The petition came to be allowed by granting the aforesaid prayers merits. Paragraph. The appellant petitioner who has otherwise succeeded in the petition for the aforesaid prayers, whom is aggrieved because of the subsequent observations and directions issued by learned single judge. They read as under. Then quote from page 34, lastly, learned senior counsel, like the third party. Full stop. It was submitted that the aforesaid directions was not within the purview of jurisdiction of learned single judge dealing with the writ petition. Paragraph. The paragraph prima facie, the submission is great substance. Submission is substance, full stop. The directions quoted above issued by learned single judge travels beyond the prayers and the compass of the prayers made in the writ petition. Therefore, appeal is admitted. The directions quoted above
Lord, I got a
shall remain
submission to make.
stayed.
Got submission to make, my lord. Out of the amount deposited, my lord, 9 crore 32 lakhs, there has been disbursement of about 8 crores 26 lakhs pursuant to the order passed by the learned single judgment.
That we are not concerned.
Yes. Seal number 50. Mr. G. Lakshmi Shah.
Happy for them.
For responding.
But on challenging the order passed by the learned single judge, but holding that the power under section 112A3 of the Municipal Corporation Act does not restrict the corporation to reassess the tax even after the expiry of 1 year period. Lords, the appellant herein is a corporation, but running a transport service. And it's not a profit-making organization and there is no manufacturing activities involved. Lords, under the self-assessment scheme, the appellant herein has furnished returns from the year 2001 to till 2010. Lord, that self-assessment scheme that I have paid the tax. But in the year 2009, the respondent herein has issued notice to me stating that the assessment made by is incorrect. My lords, I have filed a reply as per Annexure C stating that.
What was that miscellaneous application?
My lords,
What was the miscellaneous application before the additional district judge?
my lord, the show cause notice issued by the other side has been challenged before the district court. That's the miscellaneous application.
By the SSC,
Yes, my lord,
by the SSC.
that show cause notice issued by the corporation. I filed a miscellaneous application before the district court.
Who challenged the show cause notice?
Yes, my lord, assessee.
SS.
Yes, yes.
Then what happened?
That appeal was dismissed. Lord, I'm challenging the same, Lord, I am before this court by filing a writ petition. My lord, my specific contention before the court was
But I am the city
Where
corporation.
is the order in miscellaneous appeal?
miscellaneous appeal, my lord, Annexure J. Annexure J at ink page 76.
Page?
76, ink page 76.
Is your appeal.
Appeal filed by the Karnataka State Road Transport Corporation.
Appeal against which order?
I have challenged the show cause notice. Show cause notice as per Annexure F.
Who challenged? SSC.
Yes, my lord.
My lord, I appear for the city corporation. He is the KSRTC is the owner, the occupier of the subject building.
Assessee.
I am the city corporation. My lord, as regards the property tax, my lord, with respect to for the years, my lord, 2002 and 2002-3 to 2008-9, he had submitted, he had paid the property tax under self-assessment scheme. What I did is, that is city corporation, in the year 2009, end of 2009, I initiated proceedings stating that the property tax paid under the self-assessment scheme is deficit upon reassessment. So therefore pay the deficit. We issued him a show cause notice. That show cause notice came to be challenged by the KSRTC, that is the appellant before my
So there
lord.
is a reassessment scheme.
Reassessment, we reassessed it.
Self-assessment.
Under the self-assessment, he had,
They have reassessed.
under the self-assessment scheme, he had paid. So after a lapse of 5 or 6 years, we reassessed it and we said, the tax paid by you is in deficit. Please pay the difference. He
There is a
challenged-
procedure, there is a procedure contemplated under the law.
So there is under the
They have
KMC Act.
issued show cause notice. That show cause
But
notice.
if it was your own scheme, then how can you back out?
No, my lord, lord, our contention before the learned single judge was that there is no provision under the Karnataka Municipal Corporations Act to reopen or reassess the property tax paid by the appellant before my lord under the self-assessment scheme. Because my lord, what happens? The owner or occupier under the self-assessment scheme pays the property tax. My lord, in case if that tax paid by the owner or occupier of the building is according to the corporation is deficit or which it is not properly stated or undervalued, then our contention before the learned single judge was that, my lord, that the city corporation could reopen the such assessment and could ask the owner or occupier to pay the deficit. My lord, learned single judge held that yes, under the KMC Act, there's no provision, there's no limitation prescribed to reopen or reassess. But however, if no limitation is prescribed, it has to be done within a reasonable period. That is, and categorically held 3 years is the reasonable period. And further observed in the operating portion of the order that since in 2009, the proceedings were reopened, the corporation could.
So whether you can reopen or not is not the question.
Well, he had challenged the very act of the corporation reopening or reassessment, and it was a specific contention that it is barred by limitation. The issue was whether there is any limitation prescribed under the Karnataka Municipal Corporation. That was the only issue. That was the only issue.
So here, what is wrong in this order?
Lords, Lord, my specific contention before the learned single judge was, Lord, section 112A3 of the Municipal Corporation Act, it provides that whenever the commissioner or any authorized officer is satisfied with the assessment made by the corporation, made by the appellant here in the assessee, whether it is correct or complete, this exercise has to be done within a period of 1 year. My lord, this is a tag which we have been paying since 2001. 2009, they have issued a notice, show cause notice to us, saying that from 2001 onwards, totally they said that I am liable to pay 87 lakhs. When law clearly, explicitly provides that it has to be done within a period of 1 year. My lord, they did it after 7.5 years. That is a precise question before the learned single judge. The learned single judge holds there is no limitation period prescribed under the act, and therefore reasonable period is a period of 3 years. So the learned judge took up had given a finding stating that first 3 years from 2002 to 2006, it is not a reasonable exercise of power. Since from 2006, I am bound to pay. This is the order passed with the learned single judge. Lord, aggrieved by that, my lord, I am before this court. For a moment, my lords, I may be permitted to read section 112A3, if your lordship permits.
Now, what is your submission?
But my submission is the interpretation of section 112A3. May I draw your lordship's attention to paragraph 13 of the finding given by the learned single judge.
13.
13, paragraph number 13. 1.3, my lord, at page 25. May I read, my lords? Then I will take your lordships to 112A3. But may I read paragraph number 13? May I read paragraph number 13, my lord? Having regard to these aspects and the fact that subsection 3 of 112A of the Act mandates that the assessment under the self-assessment scheme shall be concluded within 1 year. Within 1 year from the date of submission of the returns filed under subsection 1, it is clear that the assessments were required to be concluded within the prescribed period. The question, however, is as to whether that could be termed as the period within which a revision or reassessment could be done made by the competent authority. On a plain reading of the provision, it does not restrict the powers of the competent authority to reassess or reopen the assessments and to conclude the same within a period of 1 year. In that view of the matter, the court has to accept the submission of the learned counsel for the respondent corporation that the period prescribed under subsection 3 of 112A is not regarding the reopening or reassessment of the self-assessment made by the owners of the properties. However, this court is required to consider what would be the reasonable period within which the respondent commissioner could have reopened or reassessed the returns filed by the petitioner KSRTC. Again, having regard to the fact that the court is dealing with fiscal matters, public money, and the nature of statute and the functions of the respondent commissioner, this court is of the considered opinion that reasonable period for permitting the commissioner to reopen and reassess the returns filed by the assessee in terms of section 112A of the Act would be 3 years. Having concluded that the reasonable period within which the respondent commissioner would have reopened the case and exercised the power of revision in the matter of self-assessment returns filed at the hands of the petitioner KSRTC, The demand raised by the period of 3 years cannot be sustained. This court is of the considered opinion that the returns filed by the petitioner KSRTC for the year 2006, 7, 7, 8 and 9 would be validly reopened or reassessed by the respondent commissioner. The petitioner should be permitted to file its objection so and so. Commissioner shall consider such objection and proceed in accordance with the impugned judgment is so and so set aside. Lord, my humble submission to your lordship is, suppose if your lordship read, I take your lordship to 112A3, which is explicit in terms, if the commissioner or the authorized officer is satisfied that any return submitted under subsection 1 is correct and complete, he shall assess the property tax in accordance with the provisions of this act and the rules made thereunder, and shall send a copy of the order of assessment to the owner or occupier concerned. Assessment under this subsection shall be concluded within 1 year from the date of submission of return under subsection 1. But having regard to this categorical, the statutory provision, which says that it should be done within 1 year, my lord, the learned single judge has interpreted that this is a case where no limitation period is prescribed. Therefore, the reasonable period is 3 years. Lord, this interpretation is wrong according to me, because whenever the fiscal statutes or whenever the interpretation of statutes in respect of a fiscal statute, if there is any ambiguity, my lord, that's correct. Otherwise, my lord, it has to be read in its entirety. Explicit terms, it provides that it is 1 year, means it has to be read within 1 year only. My lord, so I am supported by 2 judgments of the Honorable Supreme Court. My lords, paragraph 22 of this judgment, my lords, with reference to the principle, it is clearly provided in the principles of interpretation of statutes that when the meaning and the language of a statute is clear and unambiguous, nothing could be added to the language and the words of the statute. In interpreting a taxing statute, equitable considerations are entirely out of place. Nor can taxing statutes be interpreted on any presumptions or assumptions. The court must look squarely at the words of the statute and interpret them. It must interpret a taxing statute in the light of what is clearly expressed. It cannot imply anything which is not expressed. It cannot import provisions in the statute as to supply any assumed deficiency. Therefore, my humble submission, my lords.
This 1 year period contemplated in subsection 3. Yes, for completion of self-assessment. It has nothing to do with the reopening.
Reopening. In fact, subsection 4 clearly provides for reopening of the assessment. He did not read that. Subsection 4.
No, I'll also read that.
Subsection 4, my lord, this is my case. If any owner or occupier fails to submit a return as required under subsection 1 or fails to pay in advance the amount of property tax payable by him as required under subsection 2 or submits an incomplete or incorrect return, this is my case, my lord, incomplete or incorrect return, then the commissioner or the authorized officer shall cause an inspection of the land and building and may also cause such local inquiry as may be considered necessary. And based on such inspection and information collected, he shall assess the property tax and send a copy of the order of assessment to the owner or occupier concerned. My contention was that for this power under subsection 4, there is no limitation placed. That has been upheld by the learned single judge. But however, my lord, the learned single judge has held that it has to be done within a reasonable period, that is within 3 years.
My humble submission is, my lords, a combined reading of 3 and 4. My lord, what is provided is, when a commissioner is satisfied with the assessment made is correct or complete. My lord, when an exercise is contemplated that it has to be done whether it is correct or incorrect, automatically, my lord, the commissioner is supposed to assess whether it is incorrect or not. Therefore, combined reading of both 3 and 4, my lords, the only indication is that it ought to have been done within 1 year, not more than that. My lord, from 2001, I have been paying tax. My lord, from 2009, they have issued a show cause notice to me. Therefore, the assessment as contemplated under the provision, when it is explicitly provided that it is 1 year, it ought to have been taken 1 year only. My lord, when then another judgment to the Honorable Supreme Court, my lords, which says, sorry. There is a principle of an administrative law as held by the Honorable Supreme Court. But paragraph number 31.
Name like one, who is it? What is your good name?
Paragraph number 31. Let's Babu Varghese and others versus Bar Council of Kerala and others. Lordship gets it, my lord, para 31. It is the basic principle of law, long settled, that if the manner of doing a
Where you
particular,
are reading, in the first judgment, which paragraph did you read?
my lords, in the first judgment, my lords, I have in paragraph number 22, my lords.
You are as fast as.
I'm sorry,
self-assessment.
sorry.
Yes.
Paragraph number 22 in the first judgment, my lords. I thought that your lordships.
Yes, 22. It is clearly all right. Then in this.
May I read the earlier judgment, my lord, that paragraph number 22. May I read the earlier judgment paragraph?
No. We'll read out. Then now in this judgment, which paragraph?
Paragraph 31 and 32.
31 and 32. Yes, read it.
But it's a basic principle of law, long settled, that if the matter of doing a particular act is prescribed under any statute, the act must be done in that manner or not at all. The origin of this rule is traceable to the decision in so and so, which was followed by Lord so and so in so and so. Where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. So this rule has been approved by the Honorable Supreme Court in so and so, and again in Deepchand versus so and so. These cases were considered by a 3-judge bench of this court in state of UP versus Singra Singh. The rule laid down in Nazir Ahmad case was also upheld. The rule has since been applied in the exercise of a jurisdiction courts and has been recognized as a salutary principle of administration. When a statute says that it should be done in a particular way, it should be exercised in a certain way, it should be exercised in that way only. My humble submission is that in section 112A3, it clearly provides that it should be done within a period of 1 year. It ought to have been done within a period of 1 year. That ought to have been interpreted and given a finding in that manner. That's my humble submission.
That 1 year is for self-assessment,
My lords,
isn't it?
1 year period. My lord, this 1 year, this was not exercised. The power is not exercised within 1 year period.
And that 1 year was with reference to self-assessment exercise.
It's not correct. My lord. It's not for self-assessment. Once again, I read it. After the self-assessment being is made, there is a discretionary power. If the commissioner or the authorized officer is satisfied that any return which has already submitted under subsection 1 is correct and complete, after the self-assessment is made, if the commissioner is satisfied that it is correct and complete, then he shall assess the property tax in accordance with the provisions of this act and the rules made thereunder, and shall send a copy of the order of assessment to the owner or occupier concerned. Assessment under this section shall be concluded within 1 year from the date of submission written under subsection 1. I'll also read the other one. Paragraph number subsection 4. If any power or occupier fails to submit a return as required under subsection 1, it is not a case of fails to submission, or fails to pay in advance an amount of property tax payable when required under subsection 2, or submits an incomplete or incorrect return, the commissioner or the authorized officer shall cause an inspection of the land and building, and may also cause such local inquiry as may be considered necessary. And based on such inspection and information collected, he shall assess the property tax and send a copy of the order of assessment to the owner or occupier concerned. My learned friend has argued the matter by saying that he is relying on subsection 4, not on subsection 3. According to him, in subsection 4, there is no limitation period prescribed. Therefore, it ought to have been considered as within a reasonable period, the power ought to have been exercised. My submission, I strongly oppose this submission because for the simple reason that subsection 3 clearly contemplates there is an ad-strict guideline provided it's in one year. For 1 year, the exercise for the commissioner is whether to satisfy correct or incorrect, correct or complete. When you are doing the exercise, exercising a power to do it correct or not, invariably the commissioner will go into exercise whether it is incorrect also. Therefore, this 3 and 4 has to be read together. When a combined reading of 3 and 4, my humble submission is it's 1 year only. This is not a case of assessment. This is a case of reassessment only.
So subsection 4 is for reassessment.
First, the commissioner has to be satisfied whether the return submitted by me is correct or
Correct.
complete.
Subsection 4 deals with which situation?
Incorrect or incomplete. Suppose if the return is filed, fails to submit a return, firstly, whether the assessee fails to submit a return is the first class. The second category is fails to pay an advance amount of property tax payable by him as required under 2, second one. The third one is he submits an incomplete. Fourth one is incorrect return the commissioner or the authorized officer.
Correct. Any judgment you want to cite?
My lord, I would cite, my lord, I would cite. It's not ready now, my lord. It's not ready. My lord, my submission is, my lord, return and assessment, my lord. Now, self-assessment scheme is a policy, my lord, which was.
No, he says that there is nothing referable to self-assessment in
Yes,
these
ma'am.
sections.
This is only after the self-assessment. The exercise of power is after the self-assessment.
Under the Karnataka Municipal Corporation Act, my lord, there's no such thing called a self-assessment in the statute which is provided. Self-assessment was a scheme which was promulgated by the government, my lord, to ease the tax-paying process. My lord, now a owner or occupier, he assesses, based on the guidelines issued by the concerned corporation, he self-assess and he pays the property tax. He files a return, he submits a return and pays the property tax. The problem arises, my lord, when he submits an incorrect or incomplete return, or when he pays a property tax which is deficit according to the corporation. What would be the remedy which is available to the corporation? Lord, the contention of the city corporation before the learned single judge was that no limitation is placed upon the city corporation to recover such deficit tax which is due. My lord, even the district court, my lord, in the appeal has said no limitation is placed. Even the learned single judge, my lord, has held that no limitation could be placed. But however, since no limitation is prescribed, 3 years would be the reason. In fact, my lord, my learned friend's writ petition is allowed. In fact, he has been favored. The only thing is the learned single judge observes, since the proceedings were initiated in the year 2009, for the period 2006 to 9, that could be validly assessed. But insofar as the years 2002-3 to 2006-7, that cannot be that cannot be reopened. In fact, the writ petition is allowed.
I am at the point of law.
No doubt, my lord, first comes the return and then comes the assessment.
Third learned advocate, Mr. So and so for the appellant, and learned advocate, Mr. So and so the respondent, whom at length. Learned advocates for the respective parties stated that readings are complete and no further are required to be added or supplemented. Full stop, reserved for judgment. Now, if you want to give your written submissions and judgments, give before Monday, or latest by Monday, right? Thereafter will not be accepted. If you want to give it all. Great.
Great.
Your lordships passed an order
What's, one second. There's another. writ
on
appeal.
9/7/2024.
My lords has granted an interim order. This is a case of regularization where university is directed to regularize the daily wages employees. My lords, have a look at the interim order granted, my lords. Kind attention. It is order dated. Yes, conditions were imposed. In that, I like to draw my lord's attention to condition number three, my lords. First, can I supply the copy?
With your lordships kindly, Lord, I'm in USA, my lord, and I'm coming on November 8th, my lord. And this may be taken up after 10th of November, my lords.
Your voice is not reaching. Mr.
Sorry, my lord, I'm in USA, my lord, in Texas, and I'm be back on November 8th, my lords, because I come on because I became a grandfather. That's the reason I have to come to Texas. And this may be taken up on.
Let him come. 10/02, 12th November. 12th November.
My lord, pursuant to your lordship's direction. Lord, the pursuant to your lordship's direction, the university passed a resolution. A resolution has been sent to the government. Now the government has to take steps.
That is that matter. What is government doing?
Madam Lord, on 22/7/2024, the university took a decision to regularize and send a proposal to the government. The
Government has received the proposal, my lord. It has been now placed before the financial department for approval, my lord. I will apprise the court on the next date of hearing.
13th November.
Can I request, there is one more writ appeal. Was writ petition was clubbed together and common order was passed. And two writ appeals was filed. Another writ appeal, it has to be clubbed along with this present. Can I request my lords to club the writ appeal with another writ appeal number? It's the same, it's a common order which is under challenge.
Writ appeals number so and so, so take the number. To be listed together.
Listed.
Obliged.
This number 53. Narendra Kumar Patil.
My lord, my lord, this honorable court had directed them to develop or modify an already developed software 3 years back, 19 July 21. The last 3 years, they have not modified or developed software. Actually, that software could have been used for processing claims of around 22,000 deposits of Kanwa. They're all waiting for their deposits to be refunded back, my lord. 22,000 people, most of them 60, 70, 80 years old, my lord. 3 years, no compliance report has submitted, no action taken report has been submitted, my lord. They're supposed to process claims, give them refund, sell the properties. No information has been given to anybody anywhere, my lord. Most of them are senior citizens. A few have expired. They are under tension. They have been mistreated by their families, my lord. 3 years, nothing has happened, my lord. Despite orders from this very honorable court, my lord. 22,000 people, my lord.
Which order is challenged? My lord, very Is under contempt. connected matter, my lords. Your lordships have been pleased to record, my lords, that we have taken all steps possible, and your lordships, my lords, have kindly been pleased to dismiss the contempt. In fact, my lords, I have placed a memo before the honorable court, and also the affidavit of the contempt petition will be able to show that he says that he's collecting, my lords, donations.
No.
I will read out, my lords.
Yes,
I will
sir.
read out. Here, which order is under contempt? My lords, interim order passed, my lords, in a petition where. Where is that?
And 2021.
Page?
Page number 14 in the contempt petition, my lord, paragraph 2, my lord. Page number 14 in the contempt petition, paragraph number 2, my lord. The software is already developed, they just have to modify. And there are 200 such cases, my lord, waiting for the same software to be modified, my lord. Around 2-3 lakh depositors are waiting for this software, my lord. The claims have been accepted, but they're not been processed.
So you're agreed by this order? Why?
My lord, they are not processing the claims because they don't have proper software, my lord. And this is not only for one company, my lord. 200 companies have been registered under KPID. Only one company, IMA, they used it for processing claims. So I'm aggrieved that they have not developed the software, my lord. And they're not processing, they're not even verifying the claims, my lord. The depositor don't even know whether their claims are accepted,
You
rejected.
submitted the report as directed?
No.
Please, I filed a report also, please. My lord, the report.
My
has
lord,
been
they may be
filed on
directed to file a
29th
compliance report and a action taken report, my lord.
For 29th of
At least that
October
is,
2022.
that is where,
Go before learn a single judge.
my lord?
Go
Well-
before learn a single judge, petition is pending then.
No, my lord, they're all in the special court. There is no petition pending on this, my lord. There are special courts, my lord, 200 cases are there, my lord. There are at least 100 plus.
8746 is not writ petition.
No, my lord, it is here only.
It's my petition. PIL, please. 8746 is my petition.
But in that, this interim order is passed.
No, my lord, this is in 514, my lord. 514 is my petition, my lord.
Yes.
514 is my petition, my lord. In that is connected to this.
In that, this.
Yes, yes, my lord, yes, my
And
lord.
you're agreed by that.
Yes, my lord. I'm agreed that they not complied with the orders, my lord.
So what is the prayer in your petition?
Prayer is to refund the deposits, my lord. They have
Where is-
not,
Where is that?
page number.
Contempt was dismissed.
No, my lord,
But
this
in-
content was not dismissed, my lord.
Not dismissed.
Lord,
Not
a similar matter, my lords, a similar contempt was filed against my lords, an interim order passed in yet another writ petition before, which is before your lordships, my lord. Your lordships, my lord, by virtue of a very detailed order after taking into consideration, my lords, my affidavits filed before this honorable court, and also taking note of the fact that this was an interim order against which my lords a contempt have been filed. My lords have kindly been pleased to dismiss the petition. In fact, my lords.
My lord, this
both
is
the-
not related to this petition,
Sir,
my
1
lord.
minute, sir, I've taken the
My lord,
submission.
this is,
Please, lordship.
my lord, every time he comes and accuses falsely, gives false accusations, does not have anything.
Well, let you show your prayer in the writ petition number 514. Where is that prayer? Got the copy of writ petition?
Page number 9 of the writ petition, 514 of 2021, my lord. To identify all the assets and properties, to issue necessary directions to respond to immediately take steps in arresting directors and managers, to necessary direction to respond to take steps to identify deposit takers and including directors and managers, to issue necessary direction to respond to invoke section 26 of Words Act, and respond number 2, initiate procedure accepting claims and ensure deposits all groups.
So state
eligible
government,
to-
state government has made an application for Aadhaar-based identity.
Yes, my lord, but that was for IMA case, my lord. That was not for this,
Of
my
the
lord.
petitioner.
How you are agreed by this?
My lord, I'm aggrieved that they have not complied with the order
They have not developed software, they're not processing claims. The claims were accepted in 2022 November, and nobody knows whether the claims have been accepted or not. At least they may be directed to inform how many claimants are there, whether their claims are accepted or rejected. Will they ever get their money back, my lord? This is a 2019 case, my lord. Last 6 years, the depositors, most of them senior citizens, they're waiting for to know the condition of whether they'll refund the depositors or not, my lord.
My lord, in a nutshell,
My lord, deliberately, they have not been complying with the orders for more than 3 years, and then questioning the credibility and maintainability of the petitions, my lord.
13% will never know. Very quick, prayer. Meetings, in order.
Around 600 crores, my lord, has been to be refunded to the depositors, my lord. 600 crores. And the officers have seized assets. The courts have directed to be sold off, but they're not selling. And there are some stay orders which they're not being vacated, my lord. Deliberate delay of seizing the property and keep it with themselves, my lord.
my lord, there are two issues. One is with regard to IMA and the other is Sri Kanva Sauda Credit Cooperative Society. Now, what they are seeking is for an online mechanism to
Process
look into the claims, my lord. With regard to IMA, there is already a process, online process established. Whereas with regard to Kanva, we had asked the state by virtue of the Center for Smart Governance had asked for certain material. So the competent authority who looks into the claims stated that they'll do it themselves. They'll process the claims themselves. Now it is the competent authority to look into these claims and state as to by which time these claims would be addressed or looked into.
My lord, they may be directed at least to verify the claims and inform the claimants, my lord.
Would my lords permit me to refer to my lords the order passed?
Could hardly be disputed. Even by the petitioner party in person. That the order dated 19/7/21 impugned in this writ appeal. Writ appeal?
Contempt, please, Lord.
Contempt.
No, no.
Contempt, please.
Contempt.
Contempt.
No. The order was in writ appeal, my lord. Read it, my lord. 514 of 21, my lord.
So then what is the contempt of this?
The contempt because they had not complied with the order for so many days, we had filed a
This
contempt.
contempt.
Yes, the
Six-
current, yes,
Then
ma'am.
there is nothing.
Contempt arising out of writ petition,
No need to even pass the.
please.
Would my lords permit me to my lords refer to the judgment of your lordships, my lord?
It could hardly be disputed, even by the petitioner party in person, that the order dated 19/7/21, which is brought under the jurisdiction of the contempt jurisdiction of this court by invoking the provisions of Contempt of Courts Act 1971, is an interim order, which is passed in the pending writ petition number 514 of 21. In the paragraph, writ petition, the grievance is raised that thousands of depositors have deposited their money in the
Kanwa, my lord.
Karnataka, Saudara Cooperative Credit Limited. Number 10, petition, but were not paid their due amount even after the maturity period. It is contended that the depositors were forced to accept shares and other forms of investments in the Karnataka group of companies.
Not all of them, my lord. A few, very few of them. Remaining were depositors. In fact, what happened, Kanva Savarda invested that in so many other companies.
Do you want to dictate the order?
No, myself.
So please sit down.
Apologies, man.
Then please sit down. The petitioners have sought umbrella of protection under the provisions of Karnataka Protection of Interest of Depositors in the Financial Establishments Act 2004. The prayers paragraph in the writ petition is for issuing directions to respondent to authority to immediately identify the assets and properties of said respondent 10, Karnataka KNVA Cooperative Credit Limited, including Benami transactions of the group of companies. It is prayed to direct respondent to take steps to arrest the directors and managers and to identify the deposit takers who have duped the interest of the depositors, who have allegedly duped the interest of the depositors. Yet another prayer is made to invoke the provisions of 2/6 Roman small 8. What is this BUDS Act?
Banning of unregulated deposits, man. It's a central act banning unregulated deposits.
Banning Unregulated Deposit Act 2019. Paragraph. It appears that in the said proceedings, action taken report was directed by the court. It was observed that the state government shall seek approval of the central government for use of the Aadhaar identification for authentication and verification of the identity of the claimants and the secure creditors who make online claims in accordance with Section 7/2 of the aforesaid Act of 2004. In paragraph 3 of the order paragraph, the state government was directed by the court to make an application to the government of India for grant of permission to use Aadhaar-based authentication. You have done it or not?
Please,
Full stop.
in fact, I filed a report, my lords. Affidavit I filed, please, my lord.
It was further observed that the action will have to be initiated on the basis of the said. It was further observed in the interim order that the action will have to be initiated on the basis of the said inquiry report, on the basis of inquiry report, in terms of Section 37 and 37 capital A of the Act.
That has not been done, man.
Paragraph. The grievance of the petitioner is that the said actions have not been initiated. Admittedly, the state government has already made an application to the government of India for Aadhaar identification, and the report is also submitted. Full stop. Not only that paragraph, the order under contempt is an interim order which does not violate the, does not decide the rights of the parties finally, the part of the directions are complied with. The only grievance is that certain actions are not taken in terms of the inquiry report. Full stop. Since the order is interim order and the proceedings of writ petition are at large before law on a single judge to be considered on merits, the court is not inclined to entertain the present contempt petition. However, observing and leaving open for the petitioner party in person to raise all the contentions on merits before learn a single judge, including the aspect that the
My lord, that is on this court itself.
actions are not taken.
No,
The petition
not
before
the
your office.
learned single judge, my lord, before this honorable.
The petition is before this court, my lord.
These are the connected matters.
Before the court, not learn a single judge. Including that the actions are not taken in terms of the report. All such contentions will be dealt with in accordance with merits as and when raised in accordance with full stop. The present contempt petition is accordingly disposed of as not entertained.
Much obliged.
My lord, they may be directed to submit action taken report, my lord, in connected matter 514, my lord. My lords, in 514, they may be connected matter 514 petition, they may be
We'll
directed.
take up once it is listed, please.